This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.
Okay, members, welcome to the public session of the Justice Committee. And just to advise members that mobile devices, as long as they are in airplane mode, are permissible, and also devices are muted. This includes members' tablet devices. They can connect to the Assembly Wi-Fi. We are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so, or when the particular matter arises in the meeting. Can I get the agreement of the members for the oral evidence sessions on the Justice, Sexual Offences and Trafficking Victims Bill to be reported by Hansard? Agreed. Brings us to item 2, the apologies. We have apologies from Sinead Ennis, the Deputy Chair, and Emma Rogan, and also we have Peter and Gemma and Doug and Sinead, who are all joining us by Starleaf, so you're all very welcome. Robin and Rachel are with us here in person. Just to advise members that if any who has delegated their authority to vote in regards to compliance with Standing Order 1156, and Sinead and Emma have delegated their votes to Gemma. Item 3, the draft minutes of the meeting held on the 18th of November, pages 14 to 24 of the meeting pack of the draft minutes of the meeting held on the 18th of November. Just are members content that they are a true reflection of the proceedings of the minutes of the meeting held on the 18th of November? Agreed? Agreed. Thank you. Item 4 is the matters arising, and the protection from Stogging Bill draft amendments, and I will just place on record the outcome of the committee's discussions in closed session on the proposed amendments to the protection from Stogging Bill. The committee has agreed to bring forward its own amendments to clause 17 to build an obligation already there to issue guidance so that it also covers the operation of the offence. 2, to support the Department's amendments or amendment on data collection. 3, to support the Department's amendment on training, but ask if it includes subsection 4 of the Committee's amendment on reporting on training. If the Department is not willing, then the Committee will forward an amendment on this item. And 4, to support the Department's amendments on reporting, but ask that if it includes subsection 4 and 5 of the Committee amendment, if the Department is not willing, then the Committee will forward its own amendment in relation to this, and that's just for the record. Okay, then that brings us to the oral evidence, the oral sessions at item 2. And we have 4 oral evidence sessions this afternoon, so I appreciate your indulgence, members, and your help so that we can have... Oh, is there? Oh, apologies. Oh, there's some more. I was going too quick there. Oh, yes, this is... yes, apologies. Item 2. The Commissioner for Children and Young People has provided further comment on her concerns with the Justice Sexual Offences Trafficking bill following her oral evidence on the meeting of the 11th of November. These include grooming provisions at clause 2, which the Commissioner has suggested the Committee may wish to discuss with the PSNI, and reform of the child abduction notices at clause 18 to include all children up to the age of 18. The Commissioner has also advised that the proposed amendment on abuse of trust should apply to all relevant positions of trust, settings and activities, and suggested that the issue of physical punishment of children should be addressed in the bill. Correspondence can be found at pages 26 to 28 of the meeting pack. Just to note that correspondence, and just to advise members that the letter will be added to the electronic bill pack and also the bill web page. The Chair of the South East Area Domestic and Sexual Violence and Abuse Partnership, Sheila Simmons, has provided further information in respect of the child abduction warning notices as discussed during her oral evidence to the Committee last week, and this can be found at pages 25 to 30 of the table pack. We'll ask members to note that correspondence, and also it will be added to the electronic bill pack on the bill web page. Item 3, the Committee Forward Work Programme. At last week's meeting, the Committee agreed to hold an additional meeting at 9:30 a.m. next Tuesday to consider the written papers that had been scheduled for today and complete the formal clause-by-clause consideration of the Protection from Stogging Bill. An updated Committee Forward Work Programme reflecting the additional meeting and the rescheduled work items is at page 29 to 33 of the pack for your information. The written paper scheduled for the meeting on the 9th of December on a proposal for a statute rule in relation to the Special Education Needs and Disability Tribunal, which was dependent on the Department of Education, needs to be deferred, and we will be rescheduled in due course. Item 4, Minister of Justice update on the Northern Ireland Prison Service. The Minister has written to provide the committee with an update on the current pressures faced by the Northern Ireland Prison Service, which is at pages 31 to 33 of today's table pack. Ministers highlighted a steady increase in the prison population and advised that just under 40% of the population have not yet been sentenced. The prison population is expected to continue to rise as a result of the recovery of the rest of the justice system. It has not been possible to sustain the single cell occupancy policy that was put in place at the start of the pandemic, given the rise in the population. There has also been a significant increasing in the number of prison staff who are self-isolating. Out of cell time has therefore been subject to some limited restrictions, and there has been no disruption to in-person or virtual visits, and all other services have continued largely uninterrupted. Members, that is for noting at this minute in time, but at some stage it may be necessary for us maybe to get a further update from the Minister and from the Prison Service, so that we are just keeping an eye on this situation. I think I mentioned in the House the other day that it's my understanding that there's something in the region of over 600 prisoners on remand, and that is a pressure and an issue that obviously is of concern to us all. So other comments then. It brings us then to, just to say that officials have offered to brief the committee at some stage, and I think we should bear that in mind, and when appropriate then we can take that briefing in relation to those issues. Item 5 is the Justice, Sexual Offences and Trafficking Victims Bill oral evidence session with the Victim Support NI. So we've got to that part now. I was going to get there very early, and Janice, you were going to be brought in a lot earlier, but we're glad that you have joined us. Janice Bunting, the Deputy Chief Executive Officer of Victim Support NI, and you're very welcome to the meeting this afternoon. And just to advise Janice that this session will be reported by Hansard, and the transcript will be published on the committee's webpage. And just to invite Janice to briefly outline the key issues in relation to the provisions of the bill and any gaps or issues that Victim Support NI wishes to draw to the attention of the committee, and then there will be an opportunity for members to ask questions. But Janice, you're very welcome.
No. Hello, can you hear me?
Yes, we can hear you. Yes, Janice, yes.
Thank you very much indeed, Chair. We had lost connection there for a few moments, so I'm hoping that our connection will be sustained throughout this oral session. Firstly, I'd like to thank the Chair and the Committee for giving Victim Support NI the opportunity to provide evidence on the Justice, Sexual Offences and Trafficking Victims Bill. I think it's a very timely time to do this today, because this is the first day of the 16 days of action to end violence against women and girls. And it would be remiss of me not to encourage all the committee members to publicise some messaging around this. So I thought I would get that little plug in right at the start. I understand that the committee has already had an opportunity to read our written submission, and so I don't intend to go through it in detail this afternoon, but there are some areas that I do wish to expand on. I would also note it is not our intention to focus on the legal mechanics of the bill, as that is not where our expertise lie, but where we wish to add value is to speak from the victim's perspective, and that is what I hope to try and do today as well. At the beginning, it is important to acknowledge that we welcome this bill. We acknowledge that it does go partway to address the gaps that we all know need to be addressed, and it does help us move towards compliance with the Istanbul Convention. However, I think it would be remiss of me not to state our disappointment that the bill is smaller than that previously envisaged. We have detailed on page 8 of our submission some of the areas we would wish the committee to consider for possible inclusion in the current bill, and we have called for the full implementation of the Gillen Review, as we believe that its full implementation will be necessary to foster the cultural change that the justice system sorely needs in order to respond better to victims. These provisions will be a really important step towards full implementation. I suppose we are realistic to recognise that this may not be possible within this timeframe of the existing Assembly, nor would we want to see the progress of the bill as it is currently further impeded by this request. But we would strongly request that all parties commit to their inclusion in a miscellaneous bill at the earliest opportunity in the next mandate. Pieces of legislation such as that proposed play a significant part in raising the confidence of victims in reporting crimes and engaging in the criminal justice process. For too long, victims in Northern Ireland have felt that many of these behaviours have been trivialised and minimised and have not been regarded as those which leave victims feeling humiliated, degraded and embarrassed. Some tell us they are left with continuing anxieties, trust issues, depression, to name just a few of the impacts that victims feel. I hope that this bill sends out a strong message that such behaviours are unacceptable and will no longer be tolerated. However, if we are truly intent on the intended outcomes of the bill being successful and preventing future victims, it is imperative that we educate and inform people. This could be achieved through appropriately resourced awareness-raising campaigns with the general public and targeted campaigns undertaken in specific settings such as universities, pubs, clubs, etc. Something akin to the No Grey Zone campaign that was undertaken by the PSNI around consent. In education, we believe that educating our citizens about what consent and healthy relationships look like is a key component of making laws like this effective. We therefore urge that standardised mandatory relationships and sexuality education is introduced in our schools in an age-appropriate way. Appropriate training is also essential for those involved in the victim's criminal justice journey, including the PSNI and the PPS, etc. Victim recovery research undertaken by Victim Support in respect of the recovery journey by victims highlighted that the response received when victims first disclose what happened to them is a potent influencer on the victim's recovery journey. This research, which was only published a few weeks ago, is available on our website and it's called Victim Recovery Journey. As I have already stated, we welcome this bill, but recognise that key to its being successful is in how it is operationalised. And in that respect, there are a few points in the clauses that I would wish to highlight. In respect of Clause 1, we would like clarity on the terminology operates equipment. The language around this needs to be examined to ensure that it covers all possibilities and is clear and unambiguous. For example, in its current form, will it cover the use of a mirror or a reflective surface which would be used covertly to capture images? We think it is important that the wording of the law covers all potential means of upskirting and downblousing. In terms of 71A3 and 71B3, we have given further consideration to our comments in relation to our original submission and have listened to evidence presented by other experts during the course of the committee's evidence sessions. We believe that the most efficient way to ensure that this law can be effectively operationalised is to remove the need for an offender's motivation to cause harm to be proven. We are satisfied that it should be sufficient to demonstrate that the images were taken without the consent of the victim covertly and in a way that the images capture parts of the body that the victim had not intended to be exposed, violating their body privacy, dignity and autonomy. These elements capture the essence of the offence in our view, and these will need to be proved beyond a reasonable doubt. We believe to add a requirement for the motivation of the perpetrator to humiliate and degrade to also be proven beyond reasonable doubt may make the offence extremely difficult to prove, effectively administer. We would endorse the comments made by the NSPCC who referenced the Law Commission's consultation in respect of Clause 1, and we would encourage the committee to benefit from the findings of that consultation. Clause 4, the extended anonymity of victims. Clause 6, the increase in penalty for the breach of anonymity. Clause 8, the restrictions on reporting. And Clause 15, the serious sexual offences exclusion of the public from courts. We welcome these recommendations, which were highlighted in the Gillen report, as in our opinion they strike the correct balance between open justice and protection for victims. Their introduction will give greater confidence to victims in helping them to stay the course of the criminal justice system. In the course of our work supporting victims in court, our witness service staff and volunteers often see the impact on victims being scrutinised publicly. It is already difficult for them to share the most intimate details of the worst day of their lives with police, prosecutors and the court. Knowing that any member of the public can also sit in and hear those intimate details may be more than some can bear. We believe in open justice at victim support, but we do not think that public access to courts should be at the expense of victims withdrawing from proceedings because they can't face the possibility of strangers witnessing them at their most vulnerable. Under 27A2, we would request that it is explicitly stated in the legislation or guidance that support staff and volunteers such as Victim Support NI's Witness Service, NSPCC's Young Witness Service, Victim Support's Sexual Offence Legal Advisors, or SOLAs as we call them, are specified as exempted persons. Whilst it may be argued that these roles may be considered to fall under the officers of the court, it would remove any ambiguity if their roles were explicitly acknowledged. In terms of our further comments provided in our written submission, particularly in relation to the so-called rough sex defence, unfortunately we have not seen the full detail of how the final clause in relation to rough sex will be written, and therefore it really makes it difficult to definitively comment without that. What is clear is that the so-called rough sex defence continues to be used in Northern Ireland and courts across the UK, particularly in cases where victims are killed. We know it is not legally possible for someone to consent to their own death or serious harm. This has always been the case. The crux of the issue is that a rough sex defence has been used by defendants to downgrade a charge from murder to manslaughter by arguing that a death has been caused by consensual rough sex gone wrong. We do appreciate that this is a tricky legal problem to overcome, but would want to ensure that full consideration of this issue informs the bill. Whilst we wouldn't wish for this bill to fall because a solution could not be found to this problem in time, we would encourage the committee to look at the outcomes of cases in England after similar legal challenges were implemented and take account of suggestions of how issues related to the rough sex defence could be addressed, for example, points raised by the Criminal Law Reform Now Network. We would wish to ensure that we take on board all the relevant learning and ensure that Northern Ireland has a law which can be operationalised, fit for purpose and give victims and their families confidence. Finally, it is also important to highlight that the issues raised in this bill will help address criminality which occurs primarily, though not exclusively, against women and young girls. As such, there is a real imperative to help prevent these crimes from happening in the first place. We believe that a violence against women and girls strategy led by the Executive Office and supported by all the departments is key in tackling the root causes of gender-based violence. I'd like to thank the committee for their time in allowing me to present that oral evidence, and I'm happy to take any questions that you may have.
Thank you, Janice, and thank you for the evidence, both orally and also what you've previously submitted to us. Just one question before I go to members, and it's just really to see if you could outline further the reasons for your recommendation that other support workers are specifically included as exempted persons. And is there a risk that some support workers may be excluded if the approach is taken to include a list in the explanatory and financial memorandum?
The reason we're asking for that to be specified is they're not currently specified. That's where we're saying they may tacitly be regarded as officers of the court. So it's not explicitly stated in the legislation that, for example, victim support staff can support a victim going to court, nor can NSPCC support staff. And indeed, with the introduction of our sexual offences legal advisors, again, they are not explicitly stated in the legislation. It doesn't necessarily cause a problem at the moment, but I suppose our view is if it was included in legislation, it might prevent a problem from occurring in the first instance. In relation to, would the provision of a list prevent others from being considered? Depending on what that role was, I don't know that it necessarily would prevent others from being considered. It would depend on the role that they're playing at the time.
Okay, thank you for that. And you mentioned this really coming to the end of your presentation in relation to the issue in regards to the rough sex. And you've suggested the proposed amendment to abolish the rough sex defence may not resolve the defence of rough sex gone wrong in a murder case. how would you suggest that actually could be strengthened? Have you any suggestions in relation to that?
Well, certainly, it would not be, I don't think, for us to kind of make the suggestion as to how that can be improved. I think that would be down to the lawmakers and how they would consider it. What we are asking is that there are different problems that the model, I think has been looked at in terms of the English model, that the English model is throwing up problems, and that's what we're saying is that it is a tricky legal problem to overcome, but in looking at how to overcome it, full consideration is taken account of the problems that are now presented and how can these be overcome. So, for example, that's why we've directed the committee to maybe perhaps look at what's being said now by the Criminal Law Reform Now network in relation, to how rough sex could be addressed and how, for example, as it currently stands at the moment, it's either if it's not a murder, then it's a manslaughter. How that could be addressed in relation to, say, sentencing, and what the judge could consider in relation to sentencing, so that what we would be saying is, can you have a look at all of that, all of those parameters, so that whenever the law is introduced in Northern Ireland, it is as robust as it can be at that particular time.
Thank you, Janice, for that. Peter Weir.
I suppose 2 points I wanted to pick up on. I suppose taking the last point you've raised first in terms of the rough sex defence. Obviously, it's important. I suppose where it's maybe in a slightly unusual position compared to other elements of this bill is that there's an anticipated, obviously, amendment coming forward by the department, but we don't know precisely the wording of that. Whereas I suppose other aspects of this legislation, where either in a position to say, well, actually, yes, that's an important step forward, we welcome that. Or alternatively, as you've highlighted, and I suspect there'll be a few things that we'll share similar views on, that such and such will actually, it will need a further change to it, a further clear-cut amendment. But we're sitting in that grey area as regards the wording of that rough sex offence. In terms of, and I appreciate you've indicated that it's not perhaps your position really to necessarily draft that amendment, or indeed said, but is there a sort of ongoing discussion or interaction with the department to ensure that not simply, if you like, that you've put your views forward, but actually in a much more holistic way that they are taking on board what can be said to have something that's fit for purpose in terms of defence of that? Is there any level of ongoing discussion with yourselves, or is it simply now at the moment within the remit of the department and they will come forward with whatever they're coming forward with? That's the first point.
Well, you're quite correct in that without actually seeing the wording, it makes it very difficult to comment. So in essence, I'm kind of commenting on what we believe may come forward, but without actually seeing what it comes forward. And while we have contributed to, we contribute to as many consultations as we can do, but we will also, contribute our views to the department in things like the SAG committees or things in the independent assurance groups where the department are sitting and where these things are discussed. So we do have avenues by which we can contribute, and obviously if there is something such as what we're looking at now, we would also send that up to the department and ask them to kind of consider that. But there are avenues by which we can make our thoughts and feelings known.
Second issue, just want to probe with you, and again, something I know you've covered, particularly in your oral evidence to a large extent, but maybe just if there's anything further you want to expand on. It seems to me that in terms of when we're talking about victims of sexual offences and sexual violence, for instance, that in terms of the approach that a lot of victims have towards the justice system, there's a level of chill factor for victims, in that, and that seems to be a combination of perhaps the intimidating circumstances of having to bring their evidence to court, the pressure, which I think ultimately cannot be avoided, of levels of cross-examination and having, if you like, to put the head above the parapet. There isn't really a great deal of way of getting around directly that. But also, I suppose, which is perhaps, if you like, a lack of confidence in victims that they will see a productive end result, i.e. that they see a lot of cases either not coming to court, a low level of conviction, a high hurdle to overcome. And I suppose that's where, particularly, I think, again, I would share your views in terms of the issue of circumscribing the motivation side of things on it can simply perhaps be seen as here is another hurdle that needs to be overcome, whereas whether I would question really whether that's particularly necessary on that basis. But I just wonder from that point of view, is there anything further you want to say on both the chill factor, as I would certainly perceive it, for many victims of sexual offences in terms of taking this forward to final prosecution and taking it through the courts? And while I appreciate you've highlighted in your submission where you see additional things that would be brought in, and I think, to be fair, you've acknowledged, and I think we would acknowledge as well, that there are a number of actions within this legislation which move things forward and do improve things. But in terms of any gaps specifically that you believe could remove or reduce that level of chill factor for victims, is there anything further you'd like to see there directly on that particular point?
Well, firstly, I suppose, again, it's going to the question of motivation. I think what victims feel, or what victims have certainly told us, is if it's going to be difficult to prove, it's maybe something that, you know, there would be that chill factor they would be concerned about going forward. And that's why we're urging the committee to have a look at what the Law Commission, the work that the Law Commission has done in this regard. And I think that NSPCC had raised, you know, the issue of the work in their consultation in England and Wales. They had actually, sorry, excuse me, it's telling me something is happening here. They had actually raised that the possibility of 4 new offences. So they had raised, for example, the possibility of a base, which was, you know, the offence for a person to intentionally take or share an intimate image where there is no consent or reasonable belief of consent. And then they deepened that by adding 2 more serious offences, one around in relation to sexual gratification and others around humiliation. And then the offence of threatening to take, you know, the offence of someone using those images in a way that would threaten the victim because they said they were going to share them with the coercive control aspect. So that's why we're urging the committee to maybe look at that consultation to see is there anything there that would, you know, fold into our legislation which would make it better and easier, you know, and give a victim more confidence in going to court. Obviously, with the services that we have.
Can you hear us, Janice? No. Can members still hear us? Yes? Yeah.
Yeah.
Right, and log in again. She's lost her connection.
Just wait a minute. I think Janice is logging back in again. Just bear with us a minute or two, members, please. It's all going too well there. That's what happens with technology. This is the first time I've heard the committee is silent. Should do this more often.
Silence doesn't mean it's
No, it doesn't.
Chair, I was going to suggest, you said earlier, can we still hear you? I was going to say at that point, can we swap places with Janice?
Back on yet?
Huh? Is she coming back in?
No? It seems she must be trying, but she's not back into the audience yet. As soon as she comes into the audience, we can put her in the spotlight.
Right, okay.
She's not showing up
Can you hear me?
Hello, you're very welcome back, Janice. We patiently waited, so you're okay.
Thank you very much indeed. I do apologise.
No,
I just
that's okay.
completely dropped off. I have no idea why. Such is the curse of doing this via Starleaf.
Yeah.
So, in answer to Mr. Weir's question, we were saying that it is a law that is operationalised, a law that can work, gives victims more confidence in reporting their crimes. If the law cannot be operationalised effectively, that's what creates a lack of confidence in victims, and it stops them going forward. In terms of the work that we do with victims, we will always try to encourage and to meet their expectations by, taking them through what the criminal justice process is about, by explaining to them exactly in relation to how the laws are perceived. And that one of the benefits that we have experienced this year is the fact that for the first time in Northern Ireland, we have sexual offences legal advisors who can be involved with a victim right from the point of report to when they go to court. And these are qualified lawyers who can take a victim through the process, their expectation, explain points of law to them, and again give them more confidence in, perhaps staying the course. But what gives, I think, victims a greater confidence is the ability to know that in staying the course they may get, at the end of it, a conviction for the offence that they have stayed the course for.
Which I suppose, Janice, on that basis, again, maybe there's more of a comment, and just conclude with this with, it'll obviously be about both getting the wording right and getting the terminology right, but also then what will be critical will probably be the first batch of cases that ultimately will be taken under this. And I suppose what will help build that level of confidence is when actually victims see a particular law actually working in practice and it leading to convictions. There may be a slight holding back by some people until they see that happening, which is, I suppose, why the first whatever number of prosecutions happen under this be critical sort of in those early stages. But thank you, Chair. I appreciate there'll be others who want to, that's probably more of a comment than a question, so I suppose there'll be others who want to ask questions here.
Okay.
Thank you.
Thank you, Peter. Sinead?
Thank you, Chair. And it's just to follow on really from that piece Peter was referring to, Janice, and you did in terms of the consent piece, and you referenced that you'd be looking at consent as being maybe the first read and then deepening into the motivations as a maybe second or third, because I was wondering if you felt it was best that the final version of the Act would be silent on the descriptors and leaning entirely on consent. It just seems to be a reoccurring theme, and just wonder what your thoughts are. And then the problems of consent and what was consent in one specific time and set of circumstances could not read as consent at a later time.
Can I just be clear, Sinead, are you talking about things like upskirting and downblousing,
yes,
or are you talking about
yes.
the rough sex?
The upskirting and downblousing, sorry, from taking it from the top there, yes. But I suppose it's a similar debacle in terms of then maybe the rough sex at a later time, but it's still that element of consent and when it is and is not consent.
Well, again, it goes back to my earlier answer. The lawmakers will be able to write this much, much better than we can at victim support. In terms of what the victim is looking for, they're looking for, this has happened to me, and I want to report that, and is that easy for me to do, and am I going to go through a lot of hurdles in relation to that? And in eventually having the courage to take that up and report it, then it falls because there are all these other hurdles that we have to get over. What we're trying to say is, in terms of considering the offence of upskirting, downblousing, the way forward might be to, kind of ignore the motivations, but just take on board the fact that images have been taken without the consent of the individual. They've been taken, covertly. They've been taken in a way that an individual may not, want to display those issues. But if we are considering then the motivations behind that, again, how the Law Commission has maybe framed that is worth considering, and how that would work for Northern Ireland.
Thank you, Janice. Just it does, it's a very similar, I suppose, approach that's been taken by others, and I can see the logic in it. In terms of your questioning about the use of operating equipment, I would have taken the reading that you're asking the question about would it cover MERS. I would have taken that, but I do think, Chair, it would be worth us getting that commitment from the department in terms of would that be covered, and then finding out is it sufficiently scripted in a way that would ensure it is covered, hopefully when this is enacted. But thank you, and thank you, Janice, for your presentation.
Not at all. Thank you, Sinead.
Thank you, Sinead. Rachel?
Thank you, Chair, and thank you, Janice, and happy birthday again to Victim Support. I know you were celebrating relatively recently.
We were, our 40th anniversary, Rachel. It was great. I actually should be sitting here with a little bit of cake that says happy 40th.
40 years young. I had a number of comments on clause 1, but you've already covered that quite substantially, and certainly agree on the consent issue. It's been brought up a number of times to us now, and I think this is something that we do need to look at in terms of purposes and motivation. But about the under 27A2 and the inclusion of sort of SOLAs and support witness service and young witness volunteers and so on as exempted persons, I certainly think this is something that we need to consider. If it is included, maybe we can get some clarification from the department if it is already covered. But if it does need to be included, would you be supportive of something on the EFM, or is it something more on the face of the bill, perhaps in 27A2 under the exempted persons list, or else in clause 7, which talks specifically about persons directly involved in the proceedings under E, and perhaps looking at a sort of an amendment there? I'm certainly happy to look at it.
I suppose it would go down to the persons that are involved. So, for example, our witness service staff, our witness service volunteers will sometimes be asked, to sit in, to support the victim. So, where would they more readily fall in? But I'm thinking specifically of the SOLAs, who we hope eventually will be able to assist the victim in court, so that might more readily sit under a different part of the bill. So again, I think it would be worth examining where the different roles actually more readily sit, and where's the appropriate place for them to be.
Yeah, no problem at all. I'm certainly happy to look at that. And then just on that, I suppose the next section of the bill then goes on about nomination of people, nomination person to be exempted from exclusion, and only one person may be nominated by the complainant under 27A2C. So if there would then be, legal representation as SOLA and maybe support as well, then how does that balance out? But certainly happy to look at that. In terms of the possibility of expanding the exclusion of the public from court in clause 15, you'd suggested that committee consider all sexual offences. Do you see in any way that would interfere with public interest?
No, not necessarily. In fact, in many ways, it might be in the better public interest, in the sense that victims themselves would maybe have more confidence in coming forward, reporting their crimes, and then staying the course. We know that it is very, very difficult. Northern Ireland is a very, very small place, and that is one of the things that victims tell us. They are nervous about going into court and maybe seeing someone they know in relation to that, and so I think them knowing that there are exclusions in place, and obviously they're under the Gillen recommendations, they're very clear about how those exclusions can work. I think there is capacity around that. I think would give them greater confidence in coming forward and reporting the sexual offences.
Thank you. And finally, just on clauses 4 and 6, I just want to ask from your experiences in victim support, does anonymity and disclosure of information or publication of information form a lot of people's concerns that you deal with as a barrier to participating in the justice process? And I suppose that question also applies to 15 now, which was just discussed.
I don't have to hand figures that could easily answer that question in the sense that, people are saying, oh, I don't, anonymity is important to me. What I would say to you again, I think it goes to the heart of the confidence measures for victims, that these are confidence building measures, and anything that builds the confidence of a victim, I think is to be welcomed.
Okay, thank you, Janice.
Thank you, Rachel. Just want to check, no other members, any other questions? Okay. Janice, can I thank you for your time?
Not at all.
And again, just to endorse Rachel's comment, but to wish you happy birthday.
Thank you very much indeed.
And thank you for all the work that you do. And we look forward to continue to work with you and victims' support as we work our way through this piece of legislation. But thank you for your time today. Thank you.
Not at all, Chair. Thank you, and thank you, committee members. I appreciate that. Thank you.
Thank you. Okay, members, just to maybe follow up with a couple of things there. What Sinead had made reference to, we could write to the department and ask for clarity in relation to that. Was there something, Rachel, you had mentioned that we should maybe just seek? Is it about the 27?
Yes, Chair. Just in terms of, obviously, there'd been discussion there about the other people are excluded persons.
Yeah.
And it's under 27A. So and then going into 27B. So
yes.
the exclusion from public, and then there's a list of exclusion directions,
Yeah.
and there's people who all persons of the exemption of, and there's a list from A to F of people that can be in the court. And then in 7, A to E, it has persons directly involved in the proceedings, which are slightly different, and that includes legal representation, witnesses, persons in the capacity of an interpreter or other person, or members of the jury. So it could be, just to get clarification, if the likes of support services and SOLAs are involved in either 27A to A to F, or else with 7A to E, and then if they were, does that then fall under 27B, which says only one person may be nominated, and that's by both the accused and the complainant? So how does, if say the complainant has more than 2 or 3 people at their team, as I suppose it were, does that then automatically mean that the accused has the right to increase their team
Is that quid pro
for those
quo?
purposes? Yeah.
Yeah. Okay. Yeah, we can. Agreed, members. Thank you. Okay.
Chair,
Yes,
we'll
Kristen.
also source the Law Commission report that's been referred to and circulate that to members.
Yeah. Thank you. Brings us to the oral evidence session with the Northern Ireland Human Rights Commission, and the Commission is joining us this afternoon, and the relevant papers are at pages 44 to 72 of the meeting pack. And can I welcome Alison Kirkpatrick, the Chief Commissioner, Ryan Blythe, the Director of Legal Policy, Research and Investigation, Sarah Sims, Policy and Research Officer at the Northern Ireland Human Rights Commission. And you're very welcome. And just to advise you this afternoon that the proceedings are recorded by Hansard, and that a transcript will be published on the committee webpage. Alison, we'll just ask you to briefly outline the key issues in relation to the provisions of the bill and any gaps that you see, and then we will have the opportunity for members to ask questions. But can I just say, you're all very welcome to the Justice Committee this afternoon. Thank you for your written submission. Thank you for joining us today. And Alison, we hand over to you. Thank you.
Good afternoon. Thank you very much, Chair, for inviting us. I'm delighted to be here. It's my first appearance before you as Chief Commissioner. And I'm here with, as you say, the 2 real experts, Rhiannon and Sarah Sims, who did the work on the submission. It was before my time. We're here to help in any way we possibly can. So you've had a written submission. In fact, you've had a number of written submissions over the last 2 years on many of the issues addressed in the bill. So what I will do, with your permission, is confine myself to a few short points of more general nature. That'll leave more time for you to point me where you're most interested today. I know you have a very packed agenda, so I should say at this stage we're ready and willing to follow up on any points in writing, if that would be helpful. And I've already had the opportunity to listen to victim support. There are already some additional documents I can think of that might be useful, but I'll come back to that at the end. So can I start by saying we broadly welcome the bill, but we do regret that a number of issues intended for inclusion did not make their way into this bill as a comprehensive enactment. That is, for example, biometric retention, criminal age of responsibility. But more important, probably given the thrust of this bill and what we're talking about today, is the reversal of the burden of proof in relation to sexual offending and minors. We remain strongly of the view that the burden should be reversed if the criminal justice system is to be effective in protecting the most vulnerable from grave human rights violations. And the Commission, in fact, has been calling for this since, I think, at least 2013, certainly 2014, when it made a written submission. In our submission, we've set out the various human rights standards that apply, including how the right to fair trial and against conviction without proof can be balanced. So we have balanced the rights of the suspect and also the rights of the victim in those sort of situations, and we can come back to that, as I say, if needs be. We also welcome the proposed amendments and have made a full response in relation to those. So I said I'd be brief, and I intend to stick to that. 3 general points, if I may. The first is that domestic and sexual violence and abuse are all part of the same thing, and they are all grave violations of human rights, against which victims have a legal right to protection and redress through the courts. They involve breach of a number of rights, most particularly the right to life, the right not to be tortured or subject to inhuman or degrading treatment, and the right to bodily integrity. And you could say the 3 most fundamental rights of them all. That's the foundation, certainly, for the Commission's approach to this bill. It's not just desirable, we would say it's essential. Victims, it's been seen, have been failed so far, so any opportunity should be taken to correct this. And in our view, it goes beyond the criminal justice system and links directly to, for example, housing, welfare, childcare, healthcare, etc. So the bill alone, no bill alone, will tackle all of the issues if those aren't linked together. And I mentioned here in passing the Family Justice Centre opening next year in Foyle by Foyle Women's Aid, which does try to pull all of those sectors together. It's been mentioned already, the Lanzarote Convention, and all I would ask is, when considering any provisions in this bill or any future provisions, the UK government says it intends to ratify it. I would ask the committee to press for ratification. That would be an important step forward, particularly given that today is the International Day for the Elimination of All Forms of Violence Against Women. I think it would be particularly timely. The Commission would also like to remind you of the relevance of Article 2 of the Protocol, and particular relevance is through the EU Victims Directive, which falls within the scope of the UK's non-diminution obligation. So that must be considered together with relevant Court of Justice jurisprudence when developing and implementing legislation which has an impact on victims. And I'm sure the committee knows that the Commission, with the Equality Commission, forms a dedicated mechanism, and we can advise further if required. Secondly, but very much tied to that same point, is the need for really good disaggregated data. There needs to be an acceptance in the Commission's view that domestic violence and abuse is gendered, and unless that's recognised and informs a response, we'll keep going round in circles. There is a worrying tendency to use gender neutrality, which is very laudable in most instances, in a way which can actually undermine attempts to protect victims. The vast majority of victims are female, and there are many reasons for that. The research backing that up is abundant. Recognising the gendered nature of violence and abuse doesn't neglect male victims. Male victims are not served well either if the nature and scale is not properly understood. So we really need to know what we're dealing with and who we're dealing with. I think once and for all, people keep calling for it, and Judith again did. There must be a concerted effort to gather reliable data. The law needs to be tailored to meet the needs of victims. Strategies need to be developed to tackle the myriad of issues in a very practical way, and resources need to be allocated, therefore, appropriately. In our view, as well, that data should be published widely so that it can be used and drawn upon by experts, not just in the legal field or in the protection field. Local expert training has already been mentioned, so I won't labour that, but we would strongly endorse that the evidence, statistics, data collection should then feed into training. What cannot happen is that the data collection is left to, for example, Women's Aid or academic researchers alone, because they don't have access to much of this information, which is held by the police, the PPS and the court service. So it needs to be done very formally and centrally. We know the success is very poor success rate, but we don't know with any real certainty where the main focus should be. So PPS, police and court service all hold the information that allows cases to be tracked through the system and find out where in particular they're falling out. What we also lack currently is really reliable information on victims' experience of the court system, both civil and criminal, and they are both linked. Rarely is there a criminal or civil case alone, often is a mix of the two. So the Commission would say before much more money or time is spent, those views should be sought directly from victims. And lastly, can I add that there's a risk that the focus is disproportionately, I don't say it has been so far in this debate, but there is a risk that it's disproportionately focused on sexual offences as traditionally seen, offending like rape and sexual assault. The Commission therefore welcomed the inclusion of emerging new types of offending through the use of internet and social media, but also to simply make the point that these forms of offending are symptomatic of the issues, we would say, that we've been seeing for decades, albeit they're committed differently and more visibly. And I think that's quite important to keep that in mind. In the same context, we'd ask the committee to not lose sight of offending within intimate partner relationships, which we say is all part of the same sort of package. It's still the most common crime of them all and often is overlooked. So rape, for example, and these other sexual offences within intimate relationships. And no doubt you'll be hearing from Women's Aid and people like that who have particular experience and expertise who can help. Now, I propose really to leave it at that, but to invite your questions and include Rhiannon and Sarah at that stage, because they really have been working on the detail of the clauses. But having heard some of the questions earlier and the evidence of victim support, I should perhaps maybe just deal with two issues straight on. One was in relation to the exclusion from court. Perhaps that's one that the Commission can maybe help a little bit more on. We have addressed this at some length in our submission, but the Commission looks at this as it must as a balancing of rights of the victim and of the suspect. It wasn't our view that a blanket banning of all access to courts in hearing sexual offences was appropriate, but we would certainly welcome proper effective training for judges and everyone concerned in the criminal justice system so that individual decisions and individual cases are considered properly and that it should be victim-led. It is, in my own experience, just in my professional experience, I do know victims who actually want to have a public court hearing for any number of different reasons, and they don't want it to be closed to the public. So it is something that should be considered on a case-by-case basis, but we should make sure that it is properly considered. I think the problem in the past has been not properly considered or the victim invited to give testimony in relation to that. I think the other point was in relation to the rough sex defence, which was specifically mentioned. Rhiannon can talk more about this, but we have addressed this also in our written submission. And what we say is that it cannot be a defence to serious harm for sexual gratification, but we did submit an earlier written response which gave some advice in relation to what the legislation could be. And that was back in January 2021, and it's noted in page 23 of our written submission, but we can certainly pull that together and send that on if that would be helpful, a detailed analysis of how the legislation could be. So I think at that stage, maybe if I'll remain in your hands if you want some of the detail to be addressed first, or if you want to simply ask questions first, and then I can split them up between myself and Rhiannon and Sarah.
I think, Alison, might be good if we go to members, and then if there's clarity needed, then maybe particular aspects, then we can call on Sarah and Rhiannon. And can and it was an oversight on my part at the start to welcome you and to congratulate you and wish you well in your new role. And there was an overlap between you leaving a previous occupation that you had and me taking up a role on the policing board, but I can assure you, I did see many of the submissions, on papers that you worked very extensively on, and I just want to say that that was very much appreciated. So congratulations on your new role. Can I just ask, just in a general sense, because obviously the gambit of international human rights is very wide, but are you concerned that there are any other provisions in the bill or the proposed draft amendments that they may not be fully compliant in relation to international human rights standards, in that broadest sense of what we understand that to be?
I think if you, the provisions in our submission where we deal with omissions probably would covers all of that. This is maybe Rhiannon, if I can invite her to, she drafted the section on emissions and the proposed amendments, which we also welcome. Rhiannon, do you want to just say a few words on the emissions?
Yes, thanks very much, Alison. Chair, I think one of the Commission's concerns is that the issue of reversal of the burden of proof hasn't been dealt with in the present bill, and that perhaps is very much a missed opportunity. This is an issue that the Commission has flagged for quite a number of years now, and it's something also that international UN treaty bodies have also raised a concern in respect of the UK. Both the Committee on the Elimination of Discrimination Against Women and the Committee on the Rights of the Child have both called for a reversal of the burden of proof in sexual offences from the prosecution to the defence, and that's something that we hoped would have been addressed in this bill, but doesn't appear to feature. The reason behind that is to really ensure that all children are protected from legislation of this nature, and also to ensure that there is no impunity for the exploitation of children, which the treaty bodies have taken the view that that burden of proof issue contributes to.
Sorry, and Rhiannon, on that point, do you see, because one of the issues, and it's the elephant in the room when we come to this bill, and I suppose it's better that we all try to have an understanding of this. In terms of the bill, there was an attempt to try and have a focused bill, because the difficulty with a miscellaneous provisions bill is it covers from Dan to Beersheba, and it can become very wide and very broad. Then, of course, the reverse of that is when you try to narrow down a bill, then you can be accused, or you can lead to the unintended consequences of something not being included. But in relation to the issue of the burden of proof, do you see anywhere in the current, and maybe this is unfair to ask this, but we'd be happy if you want to come back to us on this, do you see anywhere in the bill where it could be included, which wouldn't take away from the intent of the bill, because obviously it has to pass a certain threshold of admissibility in relation to amendments and so on?
Chair, I suppose we haven't taken a particular view on a particular clause in which an amendment could be drafted to bring this issue in. That's not something we've commented on our advice. And I suppose we do recognise the practicalities of the more streamlined bill, and that time is very much of the essence before the end of the mandate. So one of the things we'd wanted to flag to the committee is that if it isn't possible for it to be brought in within scope of the present bill, that is something that the committee may wish to raise with the department in terms of bringing in a separate piece of legislation in the new mandate.
Okay, thank you.
To add to that, we do appreciate there is a danger both ways of having too much in a bill and having too little in a bill. And I think all we would say about that is we recognise the real genuine practical efforts to address issues quickly, but just hope that the other issues aren't forgotten about for future bills. In relation to something specific that could be done in relation to reversal of the burden of proof, maybe looking at the drafting of the Sexual Offences Northern Ireland Order 2008, it could go in there. But I could direct you back to the Marshall report, which gave a specific recommendation, and that's something, again, if we're going to be giving you some more information, perhaps I can just pull together the relevant paragraph and send that through to you.
Thank you. It
may just help in relation to where that happened. Yeah.
That would be very helpful. And then just one more question from me, and then I'll open up this to members. Evidence, or some of the evidence received by the committee, suggests that the bill should be amended to cover all forms of upskirting rather than requiring sexual gratification as a motive. What's your view in relation to that?
Yes, I think we would endorse that motive gets much too difficult, and it's if a person hasn't consented to it, then it shouldn't happen, whether it's for sexual gratification or whether it's a prank. But perhaps I think Sarah is the one who's looked at that in more detail. Is it, Sarah? Did you want to say something on that?
Sorry, just unmuted myself there. Yeah, just to support Alison and just to also come in on the back of that in relation to a recommendation just we made additionally in relation to the summary conviction. In the draft bill, it is as 6 months, whereas in the rest of the UK, it's 12 months. And just to highlight that recommendation that we made to ensure that there's equal protection across all UK jurisdictions.
Okay, we'll go then to members. Rachel?
Thank you, Chair, and thank you very much for your submission and your evidence today. I have a number of just on the last one that was brought up there, and that's on the current bill and the person guilty of an offence on summary conviction, and the 6 months and then the 12 months as well, the difference there. Now, it's my understanding that in the English legislation that those provisions actually haven't been commenced. So it is the same, but I'm not too sure if that is something that, maybe I'm picking it up wrong, but it's the standard term on summary is 6 months. Now, I'm not too sure why that's happened, but if we were able to put it on the same footing and then commence that, is that something that the Human Rights Commission would support?
I think the Human Rights Commission's concern is that there's a danger that it trivialises. And certainly if there is a different sentencing framework in a different jurisdiction or a different part of the jurisdiction of the UK, I'm not sure yet whether it has been brought into force or not. Certainly it was my understanding that they intended to. Sarah, do you know what the current position is in GB?
No, I'd have to double check. I'm just aware that Women's Aid had also raised this issue as well within their submission, just to highlight.
Yeah, I think it's more it's probably, to be perfectly blunt, it's the symbolic nature of having different sentencing thresholds on these islands that is probably the main issue, rather than 6 or 12 months being in itself a deterrent.
Yeah, no, thank you. I'm still trying to get confirmation of whether or not it has been. I know the law, in terms of this draft bill, and the law is in England and Wales is different looking, but I do agree in terms of having the fact that the difference is there makes, especially on the surface, make it look different for no apparent reason. And if it hasn't been commenced in England and Wales, that's different, but it doesn't mean that it shouldn't be the same here. And a couple of other ones, we had received some evidence last week, and we were discussing deep fakes, fake porn and cyber flashing. Would this be something that the Human Rights Commission would support us looking to be included in this bill and making sure that it is covered?
Yes.
Okay, great.
Yes, that's a short answer.
Great, that's fine. No, love a short answer. I did do Economy Committee yesterday and it was the same, so it's good whenever you just do one word answers. On the adults masquerading as children online, are you aware, just from a human rights point of view, experience or research from elsewhere, and I appreciate this is a very specific question, would there be any circumstances available to an adult being able to do this? And not just for the purposes outlined in this bill, because we had evidence from the children's sector, and we were very much trying to figure out if there was ever an occasion that an adult could masquerade as a child online. And I'm struggling to find out where that is, but just to see if there's been anything that you've ever looked at or come across that would be covered under human rights.
I think, I think again, a very short answer to that is the answer is in the word masquerading. An adult can be, and forgive me if this sounds like I'm being facetious, but an adult can be a puppet or a clown or something along those lines, but there's no real disguising that it's an adult, and it's a person communicating with a child entirely properly. and any adult with the child can know exactly what it is, who it is that they're engaging with. I can't think of a single example. I certainly haven't come across one in practice. There is no right to misdescribe yourself online. So I can't think of any right that would be protected or would even be engaged in relation to an adult's right. I can't think of any job in which an adult would be prejudiced in any way from not being able to masquerade online. The only potential area you would, I suppose, have to look at, but this is already provided for, I'm pretty sure, is in relation to criminal justice and investigations, and essentially covert human intelligence sources, that sort of thing. But that's very closely circumscribed, and there are very strict rules around that come under the surveillance provisions and RIPA and things. It becomes very dangerous when it is, for example, the vigilante groups who would also engage in this sort of activity to try and, in their words, flush out perpetrators. Yep. I said I'd be short. I wasn't as short as I meant to be, but I can't think of any situation. I don't know. My colleagues will interrupt if I'm wrong, if they can, but we haven't been made aware of one.
Okay, thank you. No, we have the police up today as well, and certainly that was evident in their submission too, in terms of sort of human intelligence. Now, why anybody would be monitoring a child is beyond me, but that is it's a whole other aspect. So no, thank you for that. In terms of the data collection, finally, you brought up about gender, and this is something that I'm looking at, and we discussed a number of times in the last couple of bills that the committee has looked at. And there's been similar issues brought up on many different issues, but also in relation to data collection around children, especially through the criminal justice system. But I just wanted to check again, in terms of the Human Rights Commission's opinion, would you see any issue at all in collecting and publishing desegregated data based on, say, Section 75 lines?
No.
Okay, thank you. Chair, that's me.
Okay, thank you. Sinead.
Thank you for the presentation and that last answer in particular, I have to say. In terms of, just to run this by you, if possible, in terms of, I hear you about the age of consent and the burden of proof and the bigger pieces that have been missed out on this, and I couldn't agree more, to be quite honest, with that. But I'm going back to something that the Chair, I suppose, presented to you, and I do wonder, in terms of the burden of proof, and particularly in sexual cases or exploitation, I am wondering, for example, the conversation we're having about moving from trying to write descriptors about the intent and focusing more on consent. Is that not a vehicle in itself that, although it may not speak directly to the bigger picture of burden of proof, but are there small but significant amendments that could be made throughout this bill that actually are in that field of supporting the victim and the burden of proof? And I'm just wondering, are there other opportunities here then where we could go further that we perhaps overlooked? I would just really appreciate any further thoughts on that. Thank you.
Yeah, I'm going to give a very general short answer to that, and then invite my colleagues to say something in more detail if I haven't covered it. There is a real danger of itemising or providing too many indicative factors when it comes to things like this, because what you can end up having, and I'm speaking now just from a practical legal perspective, what can end up happening is that courts, lawyers, juries start ticking off checklists, and if something hasn't appeared in the evidence, then that's seen as almost an evidence of consent having been given or motivation having been different, and it almost would take us back to the days when people would say there's no evidence that she resisted. So I know that's not directly an answer to your question, but it's part of the sort of general context and principle behind approaching all of these provisions. I think maybe Rhiannon, do you want to just answer that shorter point?
Apologies, Chair members, I just dropped out there and I've just been struggling to get back in, so we did miss the question.
Sorry, I don't mind going over it again, Rihanna, I'll do it briefly. I'm just, in terms of the bill that's in front of us and the clauses that are in front of us, while I appreciate it's not the body of work on the burden of proof that you had hoped, as I would have, to be in front of us, I'm just wondering, are there little chinks of opportunity throughout the bill where we could say, looking at this part, we could ease on the burden of proof to a victim, that we maybe just aren't going far enough in terms of, that particular objective?
Yes, potentially. In terms of having a bill before us that could potentially make some changes there. I suppose we just need to look at the specific clauses to see just where a drafting amendment could be made. And as I say, we would have to look at that. Again, I wouldn't be able to give you an answer on the spot on that one. It's not something that we had specifically looked at for the evidence today.
Thank you. Chair, if possible, I think that would be helpful, because whilst I don't doubt the Minister's word when she talks about a commitment to the next mandate, I'm not sure any minister has the gift of speaking to the next mandate. So whilst you may leave post-its on a desk, it certainly wouldn't be enough to satisfy me. So I just wouldn't want us to miss any opportunities, if there are any at all, Rihanna. And I'm not suggesting there are, but I know that if anybody had an eye to it, it would be yourselves. So I would genuinely appreciate if that could come back to committee. Chair, thank you.
Okay, thanks, Sinead. And I don't see any other members that have any other questions. So, Alison, can I thank you and your colleagues for joining us today. Again, thank you for your submission. Thank you for your commitment to provide some further information to us. And we look forward to continuing to work with yourselves during this bill, and also in relation to all the other work that the Commission undertakes. So for this afternoon, a word of appreciation and thank you.
Well, thank you very much as well. Thank you. We've enjoyed being here.
Thank you. Okay, members, any clear wash-up in relation to that, Christian? That point that Sinead has made, can we draft something to the department?
Yeah, we'll follow up with the Human Rights Commission.
Yes,
and get the additional information first, and then we can go to the department.
Okay. Okay, thank you, members. That brings us to the next session, which is with the Public Prosecution Service. And can I welcome the Assistant Director of the Public Prosecution Service to the meeting, and we're delighted that Kieran's with us in person, and he's had the opportunity to listen to the previous oral submissions, and I think that will be very helpful, even in terms of some of the questions that we may want to put to him. For members, the copy of the PPS submission is at page 74 to 80 of the meeting pack, and sets out the issues raised during the evidence session in the bill at our meeting on the 11th of November, and the members may want to use that, and also some of the information which is at pages 35 to 38 of the table pack. So, Kieran, can I thank you for coming to us and meet with us today? I'll just ask you to make your comments, and then we'll have questions. Thank you.
Thank you, Mr. Chairman, and thank you for allowing me to come along this afternoon and hear other witnesses. And thank you, members of the committee, for inviting me here today. As the Chairman has said, you'll have received my written evidence, and I hope that you find it useful. I intend only to make the briefest of opening remarks. I'm aware that since I have provided you with the written evidence, you've heard from a range of witnesses, and that they have raised issues that you may wish to discuss with me, and that includes witnesses who have given evidence today. I'm happy to do so. I would remind the committee the Public Prosecution Service are the independent prosecuting authority for Northern Ireland, and as such we do not generally comment on the appropriateness of any given legislative provision or suggest amendments. These are matters for the legislators. However, we're obviously keen that any criminal legislation that is passed is effective, and we're happy to give you an operational perspective. I know you'll be hearing from the PSNI later today, and they will have their own view on these issues as the policing role goes beyond just the investigation of crime, but our focus is on making prosecutorial decisions. We do not seek a conviction at all costs. Questions of guilt or innocence are for a judge or a jury, and matters in respect of sentencing are for the judiciary. We work with the legislation we're provided with, and we do all that we can to maintain the confidence of victims, witnesses and the wider public. But we also have responsibilities to defendants and their rights and to the courts. Those are my opening remarks. It's very brief.
And I appreciate that, Kieran. I think maybe what we want to try and do is maybe tease out some of what may be cases that could come before yourselves and how you would adjudicate on them in the circumstances of whether the existing legislation or as is proposed in this legislation. And just with that in mind, views have been expressed that the offence of upskirting is limited and will not cover all forms. In relation to clause 1, should the motive requirement be wider than sexual gratification or to humiliate, alarm or distress the subject of taking or recording images on a video or any other device?
As to whether it should, that's a matter that we wouldn't put forward a position on. What I can tell you is that, I know it's been suggested, and I did listen to the evidence of, particularly Professor McGlynn, who I know I watched the evidence, Professor McGlynn. I'm not going to relitigate cases that have already been before the courts, particular cases, but I know there's been a concern raised around this issue of the defence of something being a prank being put forward, specifically, if I can address that. Simply because a defence is put forward does not mean that we would accept it when making a prosecutorial decision, or indeed that we wouldn't be able to prove the case. And I would say prove the case, if we felt the case was one where sexual gratification was the motivation, that we couldn't prove that before a court based on the circumstances of the case. So we would, in a case where we brought before the court, if there was a defence put forward, we would invite the court not to accept that defence, depending on the circumstances and the evidence. And there are cases where we could point to the evidence which would be enough to satisfy, we would say, to satisfy a court so that they're sure that, for instance, the motivation was sexual gratification, or that the motivation was humiliating, alarming or distressing. So as the bill is currently drafted, I think there are many cases that we would receive that we could progress, we could make prosecution decisions, confident that we could make submissions to the court that they could be sure that the terms of the bill were met. Now that doesn't mean that there aren't additional motivations that the committee or the Assembly may feel should be added to that might cover other circumstances, but my own view and the view that we would take, having seen these cases come in, is the motivations that are added to the bill as currently drafted would cover most situations that we might see. And we, as I say, just because a defence is put forward does not mean that we accept that defence or that we're bound by that defence. We would seek to disprove that defence if there was evidence to do so.
And again, and the terminology may, and it's not used to lead you in to give a decision in relation to the drafting of the legislation. That wouldn't be what we would want to do, but would it be helpful to add the intention to exert control or power to motivation? In a sense, how wide?
Yeah.
How wide do you go to ensure the success of the intent? And I suppose that's really what the committee is trying to get at in relation to particularly clause 1 of the.
Well, I suppose I can, speaking operationally, the cases, and we have prosecuted some of these cases under the existing legislation, and as I say, I'm not going to relitigate those, but what you would see is that there's sometimes a range of motivations and sometimes a mix of motivations behind an individual who may perhaps have an intention to seek sexual gratification out of the taking of an image, but also seek to humiliate and perhaps also seek to exert some control over an individual. And so it may be that there's no single overriding motivation. But if there was a case where there was no evidence of sexual gratification being a motivation, or no evidence that there was an intent to humiliate, alarm or distress, and it may be that the only motivation that this individual had was, for instance, around the exertion of control. If that was the case, then obviously it wouldn't be covered within the motivations currently in the bill. The cases are very fact specific, but they can cover, the evidence can suggest a range of motivations for any given individual.
Another issue, and I just want, and again, it's to try maybe to draw on what is currently the approach in relation to, because there is existing legislation on a range of some of these issues. But take, for example, and it was raised, I can't remember who it was, one of the submissions that we had around the issue of telecommunications, because it has been raised, and it was alluded to earlier on by the Victims Support NI around operates equipment. Now, how wide and currently how extensive, because telecommunications for us is not a devolved issue, it's a reserved matter. And currently at this minute in time, how does the PPS pursue those type of prosecutions where there is the use of, and in the terms of the clause 1 of this bill, it is operates equipment?
Well, obviously, we're not operating this legislation because
I appreciate.
Where we do have cases where, and I'm not sure if that exact phrase is used in any other current legislation that we are using. I mean, we have a range of offences that we would prosecute that involve the use of telecommunications. Right. Some of those are simply, it's the means by which the offence is committed, so it can be used to carry threats, it can be used to try and harass people, but we also have communication offences. Article 127 of the Communications Act or Order from memory does involve the misuse of communications too. And that has not presented a particular difficulty to us. We have prosecuted individuals. I see in the proposed legislation there is further definition of what is included in operating equipment later in that clause, and the clause itself sets out not just that where someone operates equipment beneath or above the clothing, but at 71B2 that a person commits an offence if they record an image beneath or above the clothing of another person. So the operation of equipment is one variety of committing the offence. The recording of an image is another. And when Janice was speaking earlier about mirrors, I have to say it hadn't occurred to me, but I did frantically read the legislation to see how it might address it. And of course the department would be better placed than I, but I would imagine the records an image beneath clothing might be covered in those circumstances where it's not operating equipment. So short version of that answer is that we already deal with telecommunications as an offence in a number of areas, both as the means by which some offences are committed and also specific telecommunications and communication offences, and it has not as yet caused significant difficulty.
Yeah, okay. Moving on to another issue, and then if members just indicate want to ask questions, please do so that we can progress that. In relation to what we've previously heard under the human trafficking legislation, and we have heard that there have been only 4 convictions for human trafficking offences since 2017. And I suppose it's to ask how many cases, and I apologise if I can't give an exact figure, but how many cases would you say have been referred to the PPS in the time but did not proceed to prosecution?
You're right that I can't give a figure because I don't have them with me, but I'm happy to get those to the committee. I mean, what I can say on human trafficking, modern slavery, human trafficking, we do have a number of cases before the courts at the minute. We have a number of cases that have concluded and have gone through to conviction. They are difficult cases because, for the reasons the committee will understand, you very often have victims who are not free to speak to police, who may appear to the outside to be free, but they're not. In fact, they're under the control of individuals, malign individuals. And even more difficult, you might actually have victims who are being exploited, who in fact are for want of a better word, willing to be where they are, in the sense that they wish to be employed and they wish to be trafficked, albeit that they are being exploited by that, and so that deters them from coming forward. So those challenges are very significant in the cases, and I won't pretend that there's a large number of cases to go through. I mean, I know, as I say, there's some ongoing cases, there's some ongoing investigations. We work with the police and often with other law enforcement agencies across Europe and joint investigation teams to really try our best to gather the evidence in these cases, or to help the police who would gather the evidence. Obviously, but I'll get you those figures, sorry, Chair.
And thanks for that. Moving on to sort of another area, which is, and it's covered in the bill in relation to children. And again, it was mentioned about operationally how we can ensure that piece of legislation is effective and it is able to secure the intent of what it was brought into existence for. But do you believe that the bill will operationally improve the outcomes in relation to the pursuit and the prosecution of those who seek to harm, exploit and abuse children?
The provisions in the bill in respect of the children's, obviously the sexual grooming, pretending to be a child clause in particular is directed towards children, and certainly the intent of that clause is something that we support. The idea, and we do see these cases, unfortunately we see them when further offences have been committed, and we have some very, very troubling examples within our office and going through the courts, as the committee might know. As I see this proposed offence, this attempts to give the police the power and ourselves the power, if the evidence is there, to prosecute at an earlier point before that those very troublesome offences do occur, where people are, for want of a better phrase, swimming in those waters with malign intent, and if it is a policy intent that we absolutely welcome. That will be in addition to those offences that already exist for us, to prosecute those who wish to harm children and to sexually exploit children, and I think it's a welcome addition.
Okay, I'm going to go to members. Rachel and then Sinead has indicated, but Rachel first, thank you.
Thank you, Chair, thank you, Kieran. I have just following up on the Chair's comments on Clause 3 and sort of the adults masquerading as a child. The way in which it's drafted, do you think this would assist yourselves in prosecuting as it stands in sort of 22G? And in terms of, I suppose this is a bigger question, how does one prove with a view to subsequently committing an offence? Could you have a prosecution, say, the way that this is drafted, without the act of grooming having happened? Yeah. Or does that actually put a lot more pressure and a lot more evidence required because there is no act committed yet?
What I would say is, and I think the reason it's been introduced is so that action can be taken before that offence has been committed, and obviously that's what people would wish to happen to avoid the harm that those offences can cause. It's not unique for us to have an offence available where we have to prove an intention to commit an offence. There's a number of other, not necessarily involving children or this area, but for example, there's offences of carrying a firearm with an intent, with criminal intent, with the intent to commit an indictable offence. There's offences of administering a substance with an intent to commit a sexual offence within the 2008 order, or with the intent to engage in sexual activity while the victim's stupefied. There's an offence of attempting to choke in order to assist any indictable offence, and that you'll know from your work around the non-fatal strangulation is a difficult case. But proving an intent is an integral part of any criminal offence. That intent might be relatively straightforward. You might be proving to intend somebody intends to permanently deprive somebody of something. That's part of theft. You have to prove that they intend to keep what they take. You have to prove a level of intent in virtually every criminal case, where that is that they have to intend to commit an indictable offence. As I say, it's not unique. It's undoubtedly a challenge. We have to prove that beyond a reasonable doubt. But it will depend on the evidence that is obtained. In this particular example, maybe the nature of the communication itself. That again, going back to what I said earlier about the defence, we can ask a court to conclude that it must have been their intent to go on to commit this offence. But the onus is on us, and we have to satisfy the court so that they're sure.
Okay. So it's not a new kind of.
It's not a new concept, but it is part of other offences, and it's something that we are able to achieve in other offences.
Thank you. We've been asked by previous evidence sessions to look at sort of intangible forms of exchange, like reward or inducement, to ensure that it's covered in this. Is that something that would maybe make it too broad for prosecution?
I suppose what we would look for in any legislation is for clarity and for the concepts being capable of being proven in a way that, if we're making submissions to a jury or to a judge, that is clear. And I understand we see a lot of cases where young people are exploited, and it's not simply a matter of money or drink or drugs being handed over, that it is much more complex. And I suppose the challenge will be, how do you capture that in a way that we can easily put it in front of a jury and say, you can be sure that this is the reward. It's intangible, but it's the reward, and that's a drafting challenge. But it's certainly something that exists with many of the cases we see.
Okay, so it's evident in cases that you're dealing with.
Sometimes we see it alongside the tangible rewards, and we're able to show or seek to show the exchange of money or those sorts of things is what has influenced. But it's very often it's complex to put over the attachment sometimes victims feel to those who are exploiting them, and it's not necessarily material.
Thank you. In terms of the other, again, more things that we've sort of been asked to look at, and that was on the likes of deepfakes and cyber flashing. Is that something that is able to be prosecuted at the moment under any existing legislation that you're aware of, or is that something that you would welcome being explicit on a bill? I'm going to say I think that the legislation that deals with indecent images of young people includes pseudo-images. Well, I know that it includes pseudo-images now. Whether that definition could be extended to include what is known as deepfakes, I don't know, and that only obviously applies to children, to young people under 18 in the case of indecent images. So whether that could already be captured within pseudo-images or that class of victim, I can't say with certainty, but my sense is that it may be. Cyber flashing, again, I mentioned earlier, communication offences, grossly offensive communications through electronic means is an offence, and it can be prosecuted. Whether that requires it to be purely words or whether an image would constitute a grossly offensive communication, I couldn't say with certainty at the minute, but it may well be captured in the Communication Act offences. Okay, thank you. I think just, again, we've covered Clause 1 quite a lot, but it's a recurring theme that keeps coming up in a lot of submissions. And the effect, I suppose it's the effect of removing, if the committee was minded to look at removing or adding in on the consent to try and sort of knuckle down on that. And I appreciate you've gone over the defence about the joke and and just having a laugh and that kind of thing, or bonding, group bonding and so on. But if we were looking to add in additional motivations or remove them, perhaps removing 3A and B, or just having the purposes of its consent or not, operationally, does that add, if we were looking to remove, does that add additional pressures on yourselves, such as evidence and putting sort of for successful prosecution, or if it was adding in other, maybe to make a consent the sort of ruling issue, and then there could be other purposes such as sexual gratification, or if it was humiliating, alarming or distressing the person, would that add further issues? I'm just trying to see what would be the the ideal way, I suppose, if you have any opinions on that.
Well, I mean, I would make observations maybe rather than express opinions. Were it the case that the offence was purely one that the images were taken without consent and they were intentionally taken, and I know some other jurisdictions have looked at that, or and the Law Commission, and I believe the Republic of Ireland have legislation that is based around the lack of consent. My observation on that would be that would remove one of the elements that currently, as it's drafted, we would have to prove, and so that wouldn't make it more difficult. It may remove one of the challenges to us, but a consequence may be that you have only one class of offence then, that everything from the prank or the ill-judged action right up to the predatory, malicious, deeply damaging actions are covered under the same culpability or covered under the same offence, and that might create challenges for sentencers. Now, those challenges may be capable of being dealt with by guidelines or guideline cases, or identifying aggravating or mitigating factors without the need for there being any other legislation on that. But it just would, if you like, set the bar at a particularly at the lowest level to capture all of the offending, and that might dilute some of the approaches that the committee might wish to be taken to those most serious and predatory pieces of offending. But that's an observation rather than an opinion. And then to your second point, if there were, if you like, the base offence and then additional offences onto that, certainly looking for a comparison, some of the sexual offences are set out as being on a base level and then are aggravated, and a greater penalty is available to them for where, for instance, they involve penetration or other, aggravating actions within them. So it's not, again, unique that there may be an offence at one level, and then if it involves X, it is deemed to be more serious in terms of the penalties available or even the venue available. So, I mean, it's not unheard of. It's a matter, in terms of operationally, would it make it any more difficult? If it was there and it was alleged, whether it was as an add-on to the base offence, would still have to prove it beyond a reasonable doubt. So in that second scenario, where it was there in the second limb, if you like, it probably wouldn't change from how it's drafted now.
See, in relation to here in the issue of grooming, do you take the view that the proposals regarding grooming fully capture the issue of enticement?
My sense is that's exactly what they're aimed at, these additional. So you have the suite already there of the offences, and they're aimed at that rapport building and that, and we will see it with cases, as I say, which unfortunately progress on to more serious offending, that there is a period of time of rapport building between the person, if they are masquerading as an adult, or if it's even in child-to-child offending, that we can sometimes see that it begins at a sexualised nature and continues in that way, but often we see it begin in quite an innocent way. And so if by enticing you mean starting in innocent, in communications and then moving on to more malign, and I think that's what these are aimed at. And I can see how they would be able to deal with those people who go in with that intent to draw people in, to draw children in, to communicating before moving on to more malign communications.
And then there's this issue which we've struggled with in terms of trying to get our heads around clause 2 about the offence of grooming somebody masquerading as a child. Is there a risk that the effect of the requirement of the clause for the offence is to have the purpose of grooming, if that was removed and it's simply related to an adult masquerading as a child, would that have an unintended consequence? Because there's always a risk, and this is where lawyers always will seek to, because at the end of the day it will be based on the legislation as to what's is the end result in terms of prosecution. But could it have an unintended consequence?
I suppose, and this has been, and I've listened to the committee and witnesses debate whether there could be an innocent, for want of a better word, set of circumstances where an adult would pretend or would.
We struggle now to find what that is.
I'm not. I mean, I suppose, and this is an observation again.
Yes.
Thinking about it, there could be a very immature young adult who may wish to communicate on an entirely innocent basis with children and holds themselves out as being a child. That occurs to me because I've seen cases where adults over 18 are very immature and perhaps childlike in the way they go. So that simply just occurred to me as a possible one. So I suppose when you take away that the need to prove a malign intent, yes, albeit a sort of anterior intent, something down the road, you run the risk. Maybe there are examples that haven't occurred to anyone yet where somebody is there doing something. Okay, there's a level of deception and they're holding themselves out to be what they are not. But that other than that it's relatively innocent. That's all that occurs to me. And so also the comments I made to Rachel about setting that bar at that level captures everything. It captures a range of offending that you might want to distinguish between.
Yeah. Okay, Rob.
Just a very small point in that area. It's more than likely, isn't it, that if there was an immature adult who was pretending to be a child and wanted to act like a child, there's probably going to be medical evidence surrounding that. Absolutely, and I should remind, and the committee will know this obviously, but when we receive a file, it's not simply a matter of saying, well, are the evidential proofs met? Is there a reasonable prospect of a conviction of this individual? We also apply a public interest test, and so one of the things that we would take into account is that very thing. Is there maybe a medical evidence to suggest that it wouldn't be in the public interest to prosecute somebody in those cases? We'd look at everything. We look at the public interest factors are not simply concentrating on a suspect defendant. We look at the public interest and the wider public interest and also victims. But yes, you're absolutely right. Medical evidence provided would be something that would be taken into account when deciding if a prosecution was in the public interest.
Sinead.
Thank you, Chair. You'd be pleased to know most of the questions have been answered. But Kieran, thank you for your comments so far. And in terms of the point that was raised by both the Chair and Rachel Woods in terms of Clause 1, the upskirting and downblousing, and I'm going there again in terms of I understand what you were saying about if we were to strip back on intent, it would make it easier because there'd be less to prove. But, or if we were to add to intent that would be broadening the capture of the bill, but then of course there would be, in terms of prosecution, there'd be bigger evidential base to gather in. What if the bill, and there have been a growing sort of swell of opinion, if the bill was to go completely silent on intent and was leaning and pivoting on consent, is there also a prosecutional difficulty there in terms of having to prove the absence of consent?
Well, the proof of that the victim of an offence does not consent or that the defendant does not reasonably believe, so that as currently drafted, the consent clauses just at 71AC, for instance, say A being the suspect does so without B's consent and without reasonably believing that B consents. So there's two levels to it. That runs throughout sexual offences generally. It runs throughout the 2008 order. So it is for us to prove the lack of consent, and that is most frequently proven by the evidence of the victim saying that they did not consent. But we also need to prove that the defendant did not reasonably believe that the victim consented. And that's a defence that can be put forward by a suspect in one of these cases. It's something they're entitled to say, well, I believed that they may not have consented, but I believe they were consenting to me taking this image. It'll depend on the evidence. Certainly that is not on its face something that we are bound to accept without questioning. We would explore whether we can prove our case even where it is claimed that the defendant reasonably believed that the victim consented. So it's not a challenge unique to this. If you went forward with it simply being an issue of whether or not the taking of the image was consented to, that would be in line with many of the other, nearly all of the other offences within the 2008 order, and it would be something that we're well used to looking at and dealing with. Doesn't mean it's not a challenge, but it is in line with other provisions.
Yes, I appreciate that, Kieran. And is there any danger in that there may have been consent for an image, but then it is used in a different way, which consent was given perhaps at a later time? Is that something that would need to be pinned down tighter, do you think?
I mean, the use to which the image is put, because you're talking about something, if you like, that you can take away in sexual assaults and rapes, if consent is provided on earlier occasions or even earlier in the same, if you like, encounter and then withdrawn, that's still not consent. How that would read across to where you've given consent for an image to be created and that image then exists, what happens that image afterwards? I think that the offences as set out in Section 1 would be about the creating, the operating of electrical equipment and the recording of images, rather than the dealing with the images after they had been created. It may be that the department's able to clarify if that's what they intended to capture, but my reading of the legislation on those clauses certainly seems to suggest it's about the actual moment of recording or operating the equipment, that the consent wasn't there for that.
Okay, I appreciate what you're saying there. So it's that moment in time, as opposed to maybe the wrong that could happen at a later time. I'm just thinking from prosecution's perspective. Yeah, I appreciate that. Thank you, Chair.
Thank you. I just want to check, is any other member either here or online, any other question? Kieran, just to sort of conclude, and it's a more an operational question in relation to that exchange, and maybe it's something that we had a discussion with the director when he kindly came to the committee some time ago, just sort of to maybe revisit it slightly. In relation to it is for the legislator to legislate, and that's the process, and we respect the independence of the PPS. But in terms of the discussion and the operational workings of the existing legislation, you come to a point where you have case history on a piece of legislation that will lead you to believe that it is either fit for purpose, should be amended, or could be better operated. The 2008 order, which is largely, a lot of this emanates from and will be subject to. Do you believe in that overall picture that this will be an enhancement, that this will give us a better opportunity? Because the intent of the legislature is to address the issue of grooming, to deal with these problems and difficulties that are out there, and that's minimising when we even put them in that phrase, these crimes that are taking place out there. Will it give yourselves, as the independent prosecutorial body, the tools to be able to see files that can be successfully prosecuted through the court?
Well, I think, referring back to my written representations, what I would say is that the proposals, particularly around offences, because not all of these proposals impact on the way we would prosecute cases, we would welcome them broadly. We would welcome them because they do address some areas where either there's challenges around using the existing legislation, the upskirting and downbrowsing, as they're referred to. As an example, we're using legislation long before the invention of the mobile telephone. And so recognising that and introducing legislation to capture that behaviour is something we support. As I say, that notion that there is an offence available so that police can intervene and we can bring forward a case for conduct prior to the very damaging conduct, that actual grooming, that actual sexual communications with the child, that actual sexual contact with the child involves, is something we support. So to that extent, we think it does enhance what's there in the 2008 order. That's not to say that the very detailed evidence that you've received doesn't raise issues about, valid issues about a number of aspects of it, and we understand that. But in general, we'd be supportive of the provisions, and especially those around providing us with offences, or creating offences that can allow us to bring forward cases that we can't currently do. We're very aware that there is a challenge to us to have the public confidence about how we prosecute sexual offences. We don't pretend that it isn't challenging. We recently published statistics which show they're not like other offences, that the rates of prosecution and conviction are not as they are in other offences, and we know how that feeds into public confidence, and we're very keen to address that. So anything that can be brought forward to help us with that is something that we welcome.
Yeah, and Kieran, I do appreciate you drawing our attention to the issue of the statistical bulletin, because, and this is never about, in many other places it can be, about apportioning blame, because we get too much of that and trying to hang the blame on who's responsible and so on. But in terms of what would you say is the largest impediment to us successfully prosecuting these types of offences on the back of the evidence that we have in the statistical bulletin?
I should say, and I don't mean to trot this out, but it is true that we don't judge success or failure on a conviction. Those are matters for a jury. But taking the question on a wider sense, the nature of the offences, and this is widely recognised, and it's not just in Northern Ireland, it's across the world really, in prosecuting sexual offences. The nature of these offences creates inherent challenges which are difficult and prove difficult for law enforcement and prosecutorial agencies across the world. And that is, very often there are no witnesses. Very often they happen between two or a small number of people in private. Very often the forensic or physical evidence does not assist. It is consistent with the act occurring on a non-consensual and a consensual basis. And all of those areas that you might expect in other offences to find evidence to support a prosecution are either neutral or don't exist. And so we're dealing, not exclusively, but we're often dealing in a world where the issue of consent to what has occurred becomes central. And you can say on one level that's quite straightforward. Somebody says they didn't consent and that they're your witness, and you put them forward and that's the issue proven. Because of those other pieces of evidence, and it doesn't require corroboration, I'm not suggesting it should, but because of those other pieces of evidence that we might have in other prosecutions not being present or not being relevant, it makes these particularly challenging cases. So it's the nature of the offences themselves that I would say is probably the most challenging aspect of it. And that doesn't mean that we can't do better, and that doesn't mean that we can't, and all the work with the Gillen recommendations about how we make it easier and better for a victim to give evidence, how we tackle things like rape myths, how we maybe give evidence at an earlier stage through pre-recorded cross-examination. The recommendations, none of these are new problems, but all of those will help, but it won't take away from the basic issue that these are difficult cases to prosecute, and always will be. We will strive to prosecute them where there's evidence to do so, but because of the nature of them, those challenges will always be present.
Can I thank you for your... Rachel. Yep.
Sorry, thank you.
Yes.
I didn't know if we were going on to the sexual offences bulletin.
I knew when I opened it up, I was opening myself up, but I thought it was only fair to do so.
Very quickly, Chair, sorry, and I'll not take up too much of your time. I just want to touch upon Gillen and also just in relation to this. So it was recommendation 155 from Gillen, and it was on consent. and it recommended that the Sexual Offences Northern Ireland Order 2008 should be amended to strengthen the law when it comes to the issue of consent. Are you aware if this has happened? Have you been involved in any conversations about this?
I'm part of there's a cross-organisational Gillen implementation group, and the group has looked at all of the recommendations with a view to move them on. That is one of the recommendations that requires legislative change, and that's a matter for the department to bring forward. I do know that there's a number of pieces of research into how consent is dealt with in other jurisdictions that are being carried out. I've been involved in some of the research as a participant, and I know that different countries have different approaches, especially around the affirmative consent and the steps to establish consent and those sorts of things that Sir John talked about in his report. So it's you'd probably be better directing this at the department who lead on Gillen, but I know it has been looked at. It's been the subject of academic study and is the subject of ongoing academic study, but my understanding is that for anything to happen on that, it will require legislative change.
Thank you. I think that's something. Certainly, we've had conversations all afternoon and in the previous weeks about consent. So certainly, Chair, I'm obviously up to the committee, but I'd certainly welcome further conversation with the department about why it's not in here. This being, I would say, the perfect vehicle to be bringing forward that as it is to do with sexual offences. Involving the sort of another in the Gillen review in cases involving children, and the PPS were to appoint prosecutors with special expertise in the dynamics of child sexual offences with the exclusive oversight of all cases from the time of reporting to the disposal at trial. Has that happened?
The unit that I head, the Serious Crime Unit, deals with all serious sexual offences and all offences involving sexual offences against children that involve, not every single one in that it involves contact. So the serious sexual offences, and to be honest, those are the majority of the offences that we see involving children, unfortunately. So all of the prosecutors in my unit are very experienced, have received specialist training. That was established before Gillen, I have to say, 2016. And so anybody who deals with those serious cases involving children will be, will have received specialist training and will be very experienced in those areas. And similarly, when the cases go through courts, we use counsel, we select counsel who are experienced in these areas.
Thank you. And I suppose there has been, we've been getting information from the department about a pilot scheme that was put in during just recent months about expediting court cases that involved children's serious sexual offences. Have you any observations on that? Is that working well? Is that something that you would want to continue?
It's certainly something we would want to continue. I'm involved in that, and it started as a judge-led initiative operating in Belfast, and it's limited to children under 13 because of some of the challenges that come exponentially with things like digital evidence when you get older children. We've had some really significant successes in that there have been cases that have gone through the system much, much quicker than anybody would anticipate for serious sexual offences. And these are cases to go to the Crown Court. They're not magistrates' court cases, which traditionally go more quickly. But I suppose it would be only fair to say that even before COVID had come in, we were probably a little disappointed with how many cases we had seen. We had a set of criteria which we considered to be a proportionate set of criteria, but not all of the cases were suitable. They either had complexities around the investigation or other issues arose. So everybody involved in the group, and it's a group that involves the defence, the judiciary, the Department of Justice are now involved in it, considering expansion of it ourselves, and court service. It's something that we would be very keen to support because the impact of delay on children is well known, particularly very young children. And as I say, it has shown the potential to really get these cases dealt with whilst protecting the defendant's rights and not cutting corners, get these cases dealt with much more quickly. So it has potential there. We're certainly keen for it to continue, and if there's opportunity for it to expand, and if there's the resources provided to allow us to provide, it's very resource intensive, prioritising anything, and these cases can be very resource intensive. So where there's the resources available to expand it, we certainly would support that.
Okay, thank you. And finally, just I suppose just from your point of view in terms of wider sort of sexual offences and prosecution on that, is there anything happening at trial that needs addressed? You know, is there anything practically that that needs, sort of from your opinions, is there any frustrations, I suppose, at the moment in terms of low conviction rates that you know the committee could look at or discuss, or anything practically that you know needs to be implemented?
At trial in the Crown Court, obviously the decision is made by juries, and the jury room is not somewhere that is open to investigation as to why juries reach the verdict they do, and we always respect a jury's verdict. I should say the judiciary have adopted directions which are very useful in dealing with some of the issues that maybe previously might have been carried into a jury room with. Some of the myths, and the judges are very keen to direct juries you know, to disregard those things that aren't relevant. So those are things we welcome. I suppose the cases are still taking too long is probably the issue that I would say. We recognise that, we have a part in that, but it's the whole system really that needs to think about it. The judges do prioritise these cases where they're able to do so, but we recognise that the delay involved in these cases is very significant, and that can be damaging for public confidence and also for individual victims. They just find it adds to the distress.
Kieran, thank you very much for your submission. Thank you for your time. Maybe one or two follow-up questions that we'll send in correspondence, particularly around maybe some of the issues around the human trafficking and so on, just for some statistics. But thank you in the meantime, and we look forward to continuing to work with you and your colleagues in the PPS. Thank you.
Thank you very much. Thank you for your questions. Thank you.
Thanks, Kieran. Okay, members, that brings us then to the final session with the PSNI, and you will find a copy of the PSNI written submission at page 118 to 129 of the meeting pack, and also the paper at pages 35 to 38 of the table pack. It sets out issues raised during the evidence sessions on the bill at the meeting on the 11th of November, and the committee may wish to explore the police this afternoon. An extract from Justice in the 21st Century Report, which was referred to in the PSNI written submission, is at pages 40 to 44 of the table pack. And so can I welcome, I hope, into Starleaf. Yeah. Oh, are they coming? Oh, they're coming in person. Oh, that's even better. Just whenever we're waiting them coming in, maybe can we just agree that we write to the department in relation to the issues that was raised about the consent? Just happy we do that, yeah? Okay, thank you. Anthony, how are we doing? Good to see you.
How are you?
Not too bad.
Good.
Good.
You're known to the police then?
Yes, I am known, yes. Can I just welcome to the committee, and it's good to have you here in person, and thank you for taking the time to come and see us. Detective Chief Superintendent Anthony McNally and Detective Chief Inspector Lindsay Fisher from the PSNI. Thank you for your written submission, and also just a word of appreciation, and I refer to the previous job on the policing board, just a word of appreciation and thanks for the work that you do in this area, and obviously your opinion is very much valued, and there will be a number of questions that we want to try and tease out with you this afternoon. But to commence with, when we just ask you, Anthony, to briefly outline any of the key issues that you see in relation to the bill, and then we'll take questions from the members. Thank you.
Thank you, Chair. Is this on? Do I need to?
No, it's controlled. Okay. Yep, okay. That's fine.
Thanks, Chair. Thanks for your kind remarks, and thanks for the invitation to be here. And it's nice, as you say, to be here in person. So As you know, we've given our written submission in relation to this particular bill. As we said in that written submission, I think personally from a policing point of view, as we know, our role is to, where at all possible, prevent crime, but of course where crime happens, to take action and bring those responsible to justice on behalf of the victims. I think this bill helps to do both of those things. I think firstly, the additional legislation is useful from the point of view that when it becomes public knowledge, and indeed when we start to deal with these offences, let's hope that it does what it's designed to do and it deters those who may wish to be involved in these types of activities from committing the very offences that are listed. And likewise, again, we all know that sexual offences is a very challenging area in which to work and to get the justice that victims seek. So any strengthening of the legislative architecture, and in simple terms that give us more tools in the box to deal with perpetrator behaviour is very much welcome. And of course there are a number of those offences within this particular bill. We have no particular challenges with the bill in terms of as it's written. We believe that with appropriate guidance and appropriate project management akin to that we're using and seeing from the Department of Justice in terms of how we navigate our way to the domestic abuse bill becoming an offence in February 2022, with a similar structure to that. We believe that we should be able to operationalise these offences effectively. I did mention in the written submission that not just looking at this offence in isolation, but looking at the breadth of offences and pieces of legislation that we have in terms of the domestic abuse bill, this bill, stalking, domestic abuse protection orders and the other things that are in train. We do just highlight that from a policing point of view, we don't want to let victims down. And what we want is that when we have the legislation, that we are collectively working across justice and with our partners to understand what the additional demand is that this is going to bring. Obviously, there will be some demand that potentially moves from offences we may be trying to prosecute these matters via at the minute, but obviously there will be new demand. From a policing point of view, we just want to make sure that we're appropriately resourced and financed to do that, and that's something that we raise on a continual basis with the department as to how we seek to do that. But in broad terms, Chair, I'm more than happy to take your questions if that's okay.
Thanks, and thank you for your submission. And we'll just maybe go to the first comment that you make, or one of the first comments you make in relation to that. And it's always, and it's right that organisations, delivery organisations, raise the issue of resource. And you rightly said, however, we feel it's important to highlight to the committee the significant additional resource burdens that will be placed on the PSNI as a result of the additional demand these welcome provisions will create. Has there, and it probably is nigh impossible to get, it can't be definitive, but how do we go about seeking to try to get to some understanding of what that additional resource amounts to and not just in monetary terms, because we have a sometimes very narrow lens that we look through here, which is it's all just about the money. It's not just always, it is about that resource that you have in terms of the way in which the organisation is structured within departments, and there are other departments within the police who believe that their protection of the community is as equally as important as someone else's. How within the organisation is that being managed, and have we any sense of what it equates to in terms of that stress and that stretch and burden that's going to put on the police?
Yeah, so firstly, in terms of the demand question, you're quite right. It's very difficult to quantify the unknown in terms of what are new offences and obviously have not been investigated in Northern Ireland before. So what we have sought to try to do is that where there are comparators, so for example, in terms of the domestic abuse bill, we know that our legislation broadly mirrors other parts of the UK, and that has allowed us to cross-reference with them, and we believe and have believed from an early stage that the domestic abuse bill, for example, will see a 3 to 4% increase in demand. Where there's not comparable legislation, obviously that's that little bit more difficult. But we do keep that under review in terms of each piece of legislation and try to understand what it's going to mean and try to, as efficiently and effectively as possible, ensure our officers are trained and equipped to deal with it and get it right first time. Obviously, I think what will be helpful is potentially retrospectively when these offences have been trained for a period of time, we may need to look backwards and see what additional demand that has created, and then look to then how reassess and reprioritise where we put our resource subsequently. Presently within policing, you're quite right to highlight that not everything can't be a priority. So as an organisation, we do undertake on an annual basis a strategic review of what we consider to be the priorities within policing. That's presently being done for the next financial year as we speak. But it will not be a surprise that vulnerability-related offences are a priority at the minute within policing. Those are domestic abuse, child abuse, and the high-end sexual offences, and I would fully anticipate that will continue to be the case.
And Anthony, because when you start to sort of break it down into departments, you mentioned training, and I know it's very early in the cycle in relation to the introduction of the domestic abuse piece of legislation. But if we take that as an example, do you think that officers now are adequately aware of, trained in, and able to implement the domestic abuse piece of legislation? Because it's all very well, we make the legislation, then we hand it over to a number of other organisations who have to, and that does in itself put a huge demand on the organisation. So how has that operated, and does it compare to, because there's a wider scope in this bill than there was in domestic abuse. However, they are trying to encapsulate those serious offences that you just highlighted, which are on the rise, sadly, in our society. Is that training, are you happy that it has worked in a way that gives us that outcome? And then the other part of that is, because some of this is dealing with devices, it's dealing with the cyber, it's dealing with internet, it's dealing and it's something that I intend to get the approval of the committee, and we've discussed with the clerk around us as a committee going to see the cybercrime centre and trying to get a sense of how that all operates, because that is the world where not all, but a lot of this is going on. What is that needed to be updated? What resources are required there in terms of equipment and all of that makes the implementation of this piece of legislation fit for purpose?
Yeah, certainly, Chair, I'll take those in the order you addressed them. So firstly, in terms of training, and you mentioned the domestic abuse bill, there are probably two aspects to training. There's training for police and police alone, and then there's training in terms of how we are interoperable with our partners, which I think is equally as important. In terms of our internal training, we have developed a 4-stage module for domestic abuse. The first module in itself is specifically around the signs and symptoms of what is coercive control. Basically, in layman's terms, what does that look like for an officer or staff member when they see it, be that on or off duty? That then follows through to how we work with victims, how we support them, how we work with partners. So there's a 4-stage module. That has been designed in partnership with Women's Aid and the Men's Advisory Project. We felt it was really important that we speak to and work with those who deal with victims like we do, on a day-to-day basis, but we support them in a criminal justice manner. They support them in broader manner. So by working collaboratively on that, I think it's a really effective piece of training. And again, the committee members you're more than happy if you wish to come and see it. It is an interactive training module. We have probably been forced that way as a result of COVID. There are benefits to that in that officers and staff can complete it in their own time, so you can do part of it and go back to it, so it's not that you're taken away from your day job for 90 minutes to help us again prioritise all the competing demands. And it's interactive from the point of view that you have to answer and do certain tasks before you can move on to the next, so it's not like you can switch it on in the background and let it play through to the end. It is really good, and I do believe when all 4 modules have been completed by all officers and staff, they will be in a really good position to support victims of domestic abuse. Just in terms of figures, the first module was the one that we rolled out first, obviously. The other 3 are now live. In terms of the first module and second module, between the two, there's just over 5,000 officers and staff have completed them. But we will, of course, look to now prioritise those who are in frontline roles, but I do believe it's as applicable for any officer or staff member to view them all. We will continue to use that methodology for the next series of offences. So this bill, I would propose that our training style, if you wish, will follow suit because it has worked well. And we'll look to do that for this bill and then others that follow. In terms of the cyber world, it's not my direct area of responsibility, but I do know there are some challenging conversations around prioritisation. You will absolutely understand, and as you highlighted yourself, Chair, there are not many offences nowadays that don't have a cyber element, but you have to prioritise. And those don't come without challenges. And indeed, I know that my cyber colleagues are in the process of rescoring, if you want, their prioritisation matrix because it is a number of years old. And we always look to make sure that it keeps track with what we're seeing in terms of current crime trends. So, for example, one of the things that I understand that is perhaps scored slightly higher than maybe a few years ago is child sexual exploitation, as we continue to understand that particular offence and the behaviours behind it in order to be as proactive as we can. So hopefully that answers those questions.
Just moving on to the issue of, in your submission you make reference to the potential legislative gap in respect of grooming offences. Do you see, is there more that we could do? And what would that be in light of this legislation that would help? Because the purpose of the legislation surely is to give yourselves, as you mentioned earlier, the appropriate and the right tools to be able to bring someone to a conviction and to keep people safe. So what is that gap, and what do you see, except the fact you're not a legislator, so that we're not asking you to write the legislation, but what would it be if it was in your gift to have it that would help in the carrying out of your duties and your officers?
Yeah, so I mean, firstly, we recognise that the grooming offences is written in terms of the ages that are put in place largely follow the 2008 Act in terms of someone over the age of 18 committing an offence against someone under the age of 16. But I suppose we saw this one slightly differently because operational experience has shown us that there are occasions when people under 18 have been preying in a manner on people under 16 to carry out these offences. Indeed, one of our most serious investigations commenced when that individual was still a child themselves and carried it into their adulthood. So it was primarily with that in mind that we felt that you could be 17 or 16 but preying on a 10 or 11-year-old with a view to committing these offences, and we just wanted to highlight that as a point of consideration for both the committee and the Department of Justice.
Okay, thank you. We're going to go to members who have questions. So Rachel, and then if other members could please indicate, and then we'll take them as I hopefully see them on the screen. Thank you.
Thank you, Chair, and thank you very much for your submission and for coming. Certainly agree with your comments in terms of resourcing. I mean, we tried to do this in the domestic abuse bill and put it on the face of the bill. That was sadly turned down, but I don't think we can keep legislating for new offences without increasing rate. I mean, it just doesn't. You can't. Something has to give on that, and then just put it all down to budgets, because it's not, as you say, just about financing. In terms of the clause 1, we've had a lot of discussion about upskirting and downblousing in relation to the purposes of sexual gratification, and obviously then with humiliation, alarm or distress. If we look to change that and just put it on a consensual grounds only, would that, for yourselves, do you think, in terms of ability to gather evidence or actually, investigate that, is that something that would be easier, do you think, or would put any more challenges in place, or just leave it as it is and see what we're working with?
Yeah, no, I absolutely understand the rationale behind the question. From a practical point of view, consent is something that we seek to have to prove in a number of pieces of legislation. So it's not something that we're unfamiliar with, and that's part of the evidence gathering piece that police officers and staff will do in terms of gathering the information that aligns to consent. And I know from other submissions there have been conversations and considerations around, is then an alternative to that? Do you look at expanding humiliating, alarming and distressing behaviour to include other things? And I know prank is specifically been part of those conversations. But from a policing point of view, in terms of the consent and the intent perspective, that's what we see as our job. Again, many offences cover both of those areas. Drugs with intent to supply, firearms with intent to carry out criminal act are things that we have dealt with. So we would say that following that same train is familiar territory for us, and I would argue other criminal justice partners, and any sort of defence, if you wish, around a lack of consent, and defences around pranks are things that, from a policing perspective, that we'll deal with in terms of the evidence gathered, be that an interview, be that through what someone may have stored on their devices, that you can very easily prove, well, actually that wasn't a prank, you sent it and typed these nasty comments after, so on and so forth. So broadly, as I say, I think in terms of our position, we were content with the bill as written, but totally understand why those questions are being asked.
Okay, thank you. In terms of, again, this is something that's been brought to our attention on the threats to share intimate images and the sort of image-based sexual violence. I suppose there's two questions. Is that something operationally that's increasingly reported to yourselves? Is that something that has been on the up? And also, if the committee were minded to look at the likes of deep fakes and fake porn and cyber flashing, again, from an operational or practical perspective, would this be something that the PSNI are receiving increased supports or increased reports of?
Yeah, I couldn't give you the sort of exact detail in terms of where there are images involved, but certainly the two pieces of legislation where that may come into train at the minute is around harassment, less so malicious communications, because it's more about the communications than the images as such. But in terms of the practicalities of those, I can see that it may be beneficial, but I can equally see particular challenges in terms of how we may investigate those. That will be very much within the cyber arena. Again, I'm not convinced that really changes the landscape, and I think the legislation probably as written covers most of the things that, and with existing offences, that we would seek to utilise.
Okay, thank you. There's the department given an indication that they're going to be bringing amendments that further down the line on a number of issues, and I know you've covered some of them in the responses. I'm just wondering, is there's a common theme coming through about the rough sex defence, that perhaps communication or hasn't been great, or there haven't been any sharing of the department's intention of what they're actually going to be bringing forward. Yeah. Have you had any communication or any engagement with the department on the specific rough sex defence from your policing perspective?
Certainly I haven't, but I do know that the department, we have had some early conversations around how we will start to operationalise this bill, but I'm going to ask Lindsay if you specifically, I have not specifically had any conversation on rough sex.
Not in respect of that. We have had early conversations, obviously, in respect of non-fatal strangulation and the, I suppose, the reprofiling of that particular offence, but no indication in terms of timeline or where that will sit.
I suppose then very quickly, and I'll finish just on, and this is on the, so the and again another thing that was brought up to us about the things that are not in the bill. And we had a conversation, I believe it was with the migrant group, the support group, a couple of weeks ago, about legislation that just been enacted in the Republic of Ireland on convictions for through no fault of their own for around 600 women with prostitution-related offences. Is that something that you would consider beneficial? I know just they and Garda Síochána have welcomed that legislation, but if there would be a similar approach taken here in Northern Ireland, is that something that you think would be beneficial?
I have to say I haven't seen that, and if that's one you wouldn't mind, we could follow up with and write, and I'd be happy to do so when I'll check the Republic of Ireland's legislation and come back to you.
Thank you. Thank you. Just on a one query before we go to Robin and then Sinead. It's been raised a number of times, and we need to be clear. And it might be useful if you could provide for us, Anthony, at some stage, where the law in Northern Ireland lies in relation to the whole issue of telecommunications. Because some of it is not devolved, some of it is able to be pursued by our own current domestic legislation, but there seems to be whether we call it a gap or a differential between what powers we have and what powers we don't have. That might be helpful if that could be communicated to us, excuse the pun, in terms of
electronically
an understanding of what is the position in relation to able to have you all the resources legally to be able to pursue telecommunication crimes.
Are you referring, Chair, specifically to the malicious telecommunications?
Yes, because if you take the whole, go back to the policing board days, the stop and search stuff has always been on the basis of, the Telecommunications Act and so on. But in relation to all of this piece of legislation, where is there, or is there a gap between what we currently have and what we can use, what effectively is able to implement this legislation, or is there still a challenge that we need to have some other powers given to us in relation to the issue of telecommunications?
Yeah, I can certainly take a look. So malicious communications has been an offence in Northern Ireland since 2018, I believe, specifically, and it's one that is on the increase. We are seeing an increase year on year in terms of reports, which is unsurprising. Our outcome rate for it is one that we're working on. It presently sits somewhere around 17–18%. So yes, by all means, I'll take a look at that and come back to you.
Okay, Robin?
Thank you, Chair, and I thank Detective Chief Superintendent McNally and Lindsay for being with us today. Can I, you had, and it's maybe picking up on one of the first points that the Chair had raised, you had made reference to, the bill is a useful bill, you would believe. You'd obviously want it to be designed what it is intended to do, and you don't want to let victims down, and none of us want to let victims down. And in your concluding remarks, you had placed a fair degree of emphasis on resources and needing resources. You also referred to when other legislation was implemented that you'd done comparators with other parts of the UK and what experience had been and so on. Can I just ask, in terms of legislation that is coming forward, at what stage is there a skills audit within the PSNI to say, if this legislation comes forward, here's what we need to deliver what the public expect out of this legislation in terms of either knowledge gaps, experience gaps, equipment gaps, or does that not happen in the organisation? That a skills audit is at some stage prepared to ensure the smooth transition from the law being made to the law being operational and indeed the victims being supported?
Yeah, no, absolutely. So probably the best one to use is, by way of sort of contextual example, is the domestic abuse bill, and that's exactly what we have done. And that commences, we probably have some conversations before we know the bill is finalised, because there's no point waiting to the very end to start, particularly if there's a short turnaround time frame. So, for example, in respect of the domestic abuse bill, we set up a project team led by me to oversee the implementation of that, and effectively it is in a proper sense of collaboration and whole systems thinking across the PSNI, because there's no one area of business is not affected by any piece of legislation. So if you take, for example, that bill, so what is the impact on a call handler? So when we've got a new piece of legislation, what do they need to know differently around when that first call comes in to say, I've been coercively controlled? What does that mean? How that then translates to those who attend those calls, how that translates to custody. So does the custody sergeant understand that legislation? How that translates to the files, and that's where we work with the PPS in relation to how we engage with prosecutors around what they expect and what we expect, and all of those things. So there is a system that sits above looking at that. There's a project management system that looks at that whole systems approach. So the areas within that will be communications. So how do we need to communicate with the organisation and partners? Training is a huge part of that. As you quite rightly say, IT in the domestic abuse bill has been a massively impacting factor in relation to how we operate across the criminal justice organisations, and then how we work with partner agencies as well, because again, a lot of these things won't just impact on us. So again, if you take the domestic abuse bill or even this bill, what does this mean for the MARAC arrangements, the multi-agency risk assessments for domestic abuse victims? What does it mean for the public protection arrangements for Northern Ireland? Are people going to be eligible to be registered within the public protection arrangements? So there is a project management style that looks at all of that whole systems piece. Project management probably cover those broad themes. So I can assure you it's extensive. It's collaborative. We do it with all of our partners where we need to reach out, and I think hopefully, he says, that we'll show that it works when the domestic abuse offence goes live.
Okay, and would it be right to say, I use the expression skills audit, that's probably too narrow based on what you have said, but would it be right to expect that there is a document produced or a strategic document produced to say, in the event that this bill coming online, here is exactly what we need? Is it a written down document so that you, as having responsibility in this area, know that you've got in place all the resources and all the actions and indeed the budget associated with it?
Yeah, so we track all of that through the project management. So that's why I'm able to tell you today, Lindsay, on a weekly basis, checks how many people have trained and on whatever module we're focusing on, and targets the areas of business. For example, our district police and colleagues who are the frontline attenders and our call handlers. So yes, we manage that, and from our perspective then as well, you know, there's a monthly sort of briefing document, a short couple of page summary is provided to the Chief Constable and his senior team just on where we're at, and that's an opportunity to highlight any risks as I see them that we can't resolve, but and then we lift it to that level. But thus far, I believe we're on track for the domestic abuse bill.
Okay. And in terms of this piece of legislation, where are you with the process you've just outlined for this piece of legislation coming online?
Yeah, so that's so I've engaged via email. I think the last one was about 2 weeks ago with the Department of Justice. I should also say the structure that I have just outlined for policing is a merged structure of how we operate across agencies, because there's no point me doing it in isolation. Everyone else needs to do the same.
Of
course. Prisons, particularly the PPS. So that structure, we have an internal version for the policing aspect and an external version for how we all work together, and that's led by the department. My ask is that that similar structure is put in place for the implementation of this bill. That ask has been made to the department.
Okay, and if the committee could be helpful to you, in how would the committee be helpful to you in that process?
I think it's just reinforcing to the department the importance of a structure, so that we're all on the same page at the same time, and when the legislation becomes live, we're all, to use a football parlance, match fit in order to protect those who it's designed to protect, and detect those who it's designed to detect.
Thank you, Chair. Thank you. Thank you.
Thank you. Sinead?
Thank you, Chair. My points have been mostly covered. I just will raise one issue that's still sort of at the back of my mind, and I appreciate the Chief Superintendent and Chief Inspector's presence here to maybe just speak to this. In terms of, I'm really conscious that we're putting quite a lot of legislation through that is heavily dependent on that cyber type of, offence. And we're already aware and have been made aware of the limitations of within the PSNI in terms of phone triage and all of that. But I'm also aware of some of the types of vehicles where this offence may, in terms of clause 1, for example, the upskirting and downblousing and then publishing. So, for example, and I will name them because the example could be something like Snapchat, where the evidence is no sooner up there and it's disappeared. And I can see how that would operationally be a real challenge for the PSNI. And the Chair spoke about that piece about, the powers that may rest here and don't in terms of the telecommunications. But on an operational, day-to-day working on a case, has there been any improvement in working with some of these very large companies who it's really difficult? I know as a constituency level, it's very, very difficult to communicate with. And has there been any change in that access of information or working with those companies, and rather than it being totally reliant on the legislation, is there any goodwill being expressed to the PSNI in gathering evidence? Thank you.
Yeah, thanks. That's a really interesting question. There is no doubt, and you will have seen stuff in the media over the past few weeks, the number of referrals to the PSNI from the National Crime Agency in respect of online child abuse has increased by 600% since 2013, which is an absolutely staggering figure. And obviously one begs the question of, well, what do we do to prevent this? Because frankly, you just simply can't arrest your way out of it. There needs to be a more holistic system society approach to that. There are a number of pieces around that. Firstly, in terms of the prevention space, focusing on attitudes and behaviours. The Lucy Faithfull Foundation have a Stop It Now campaign, which the PSNI re-promoted last year, which is aimed at for anyone who is potentially considering or feeling that they want to access images. It's about support to try to stop them from doing that behaviour, or if they've done it, from re-offending or redoing it. So there's lots of work and lots of good charities here in that space. The online harms bill is really where we are focused from a policing, both locally but also across the UK, in relation to this area. The online harms bill, as written, allows Ofsted to fine tech companies significant sums of money for failing in an efficient way to deal with indecent material that's on the internet. It's primarily aimed at children in that regard. So that's very much welcome, but obviously that legislation is not in place yet, and that's something that is being worked through at a UK government level. I suppose for me, I don't think there's any dispute in my mind that this could be stopped from being uploaded. There is, I'm sure, enough artificial intelligence and significantly smart software that can detect that something just isn't right and it shouldn't be uploaded. And that's the utopian position as a police officer I would want to see. But thus far, the Online Harms Bill is very much focused, as I understand it, in relation to when it's there, that it's taken down, and it's taken down promptly so that it can't be reshared and reshared and cause the harm that we know that it does.
Sinead?
Yes, thank you. I appreciate that, Anthony. But I suppose I'd just like to know, in terms of, hopefully those numbers are just staggering and disgusting, to be quite frank. And in terms of then, from those numbers, what you extrapolate from that actually presents as a case for the likes of yourself to have to deal with. And then it's that goodwill piece. I agree with you wholeheartedly. I think artificial intelligence, and it's not a world I know anything about, and I'm always staggered by what can be achieved, and I believe if the will was there, what you're saying could be achieved. But is there any sign of a culture change where there is more goodwill, I suppose, for want of a better expression, from companies, that they're starting and wanting to engage in actually being a positive impact in bringing cases against the perpetrators of these acts?
Yeah, I think it's fair to say that there is. Part of the reason why there is an increase in referrals is because there's an increase in the tech companies reporting this type of crime to law enforcement. We largely depend on them telling us about this, so there has been an increase in that, and that's why that increase of 600%. Part of the reason is because there's an increase in reporting, and I guess part of it is there's an increase in offending. And I suppose it's important to say as well that a lot of this is a global issue. It's not local to Northern Ireland nor the UK. So a lot of the indecent images that people may be looking at in Northern Ireland can have been uploaded from any part of the world. So there is the need for the tech companies globally to be working with law enforcement, and then for us locally, when that lands with us, it's that ability to proactively and efficiently and swiftly take action for those who have offended. But I do also think as well not to lose sight that it is through the Safeguarding Board, who do a fantastic amount of work in the child environment as well in terms of their online safety group, and the likes of the Lucy Faithfull Foundation, that actually we need to call this out. This behaviour is not acceptable, and society needs to really focus on that.
Thank you, Anthony. Thank you, Chair.
Thank you, Sinead. Just want to check there's no other questions from the members online. And just to conclude with, Anthony, you did mention in the annex to your submission that there are 4 additional recommendations and consideration for comment which are not included in the current draft bill, and obviously the legislative fix in regards to Schedule 2, the abolition of rough sex defence, which we've covered in previous oral evidence already today, the extension of the existing revenge porn provisions to include the threat of publication, and the provision to widen the scope and strengthen of the current law on abuse of trust. So obviously those would be, you believe, more than worthwhile to have included in a piece of legislation, because they will be of great benefit and value to yourselves.
Certainly like to see the draft of them, Chair. Yes, absolutely.
Okay. Anthony and Lindsay, thank you very much for your time with us today. Thank you for your submission, and again, thank you for the work, the ongoing work, because 24 hours a day, sadly, the police are being contacted about many of these things. But thank you for the time that you've taken today to come and be with us, and we look forward to continuing to work with you. Thank you very much.
You're welcome, Chair. Thank you, members.
Thank you. There's just a couple of things to follow up on. Maybe just in that last point in relation to the 4 elements. Maybe worthwhile writing to the department and asking them to comment and give us their view as to why they couldn't be included in relation to the existing piece of legislation. And was there anything else following on from that presentation that we need to raise with the department? Yeah, Robin?
Sorry, Chair, raise with the department, no.
No, right.
Well,
yeah, okay.
Well, you can judge whether you raise it with the department or not. Obviously, from what was said and what they say in their concluding remarks, I mean, they make the point, however, as above, we would respectfully ask the committee to consider the significant resource impact inevitable increase in demand will have on the PSNI, particularly in the public prosecution branch, public protection branch, cybercrime centre and economic crime unit. Now, you don't put that into a report such as this if there is not down the line some concerns on can we deliver this piece of legislation, and as Chief Superintendent McNally indicated, they don't want to let the public down, the victims down in this area. So he outlined successfully what they were doing for another piece of legislation, and now we're bringing this legislation forward as well. Now, there may be some overlap in the 2 pieces of legislation, but that, I think, Chair, is a significant paragraph in there of concern about delivery. And delivery within the areas that they've highlighted, public prosecution, cybercrime centre and economic crime,
No, and I think one of the difficulties too in this is, and I think we've heard it before, even in questions that have been raised in the House, is that, and it's too simplistic an answer to give. I'm not being disrespectful to either the Justice Minister or any other minister, but to say that it's just an operational decision for the Chief Constable, i.e. the organisation gets X number of £1 million, and it's therefore entirely up to the Chief Constable and the Policing Board to determine how they spend that resource. So I do think that it is something that we should write to the Minister specifically in relation to the comment that is raised in that submission about, and we've had it on a number of occasions, the domestic abuse piece of legislation, any piece of legislation, because ultimately it will, in most cases, be with the police, who will have to be the organisation that operation. What's the word that was used when it's operate? Oh, I can't get it. But it's put into operation.
Yes.
Yep. Yeah. That's it.
Well,
okay. Yes. We're happy to do that. Rachel.
Just to touch on that as well. We're just looked at the Stogging bill. This is not. It's not just this bill. Domestic abuse. That they knew that there was going to be an increase, and Anthony touched upon it by 3 to 4%. That's what might have been in comparison to other jurisdictions. But we did have this discussion on the floor of the House at consideration stage, and it was put that this is an operational and budget matter, but it's not just budget, as they've been very clear. This is about adequately resourcing units. And we're going to have a situation. Just go, in future proofing, we talk about this all the time, how to adequately deal with and future proof against it. Online is not going away, it's not going to stay the same, it's only going to increase. So if there's very, very clearly from their submission, and this is submissions before as well, that have kind of been skirted over a little bit, clearly there is an issue that you can't do everything with what they have, but if there's obviously going to be increasing in online and telecommunications and and how to deal with we don't even touch upon not the traditional, using traditional websites. We're not even talking about the dark web here. That's a whole other ballgame that's not been talked about. But we can't keep passing different criminal convictions and different offences and not then establishing new or improved resourcing. Because otherwise then, and that feeds into public confidence.
And they have, Chief Superintendent McNally mentioned the 3 specific areas. Yeah. And he was able to outline what sounded to me like a plan, Chair. I used the term skills audit. Yeah. He used what I think sounded like a plan. And you would expect that to happen if a business was taking on a new area of activity. You'd expect the business to research the area of activity and decide what the shortfalls were to deliver the new activity. And it's not too dissimilar. It's not the same, not exactly the same, but not too dissimilar. And I think, Chair, if the committee were minded, your suggestion of writing to the Minister to find out, and to be specific, not just say it's an operational thing, it's a budget thing, but to be specific on how we're going to deliver against new legislation that is coming down the line, and not just one piece of legislation, but several pieces of legislation.
Yeah. And when you get, and Sinead, described it adequately in terms of, when you get a senior police officer saying that a particular crime has risen by 600%, I mean, how does any organisation start to deal with that? And it's not a simple, well, we'll take X number of officers from here, we'll put them in here, and it's probably not dissimilar to what the argument could be used in the health department, the amount of issues that are there. And it is a real problem, but those figures are more than scary. Like they are, it's awful to think that any particular crime could rise by that amount. And as Rachel has said, there's probably things going on out there that we just know nothing about yet. And it's an awful. So I do think we should initially, because it is a department's responsibility in terms of the legislation, we have been highlighted very specifically in relation to that submission today, and I think we have a duty to raise it. So your agreement, that's what we will do. Okay, thank you, members, and I do really appreciate your help through those. Those were useful sessions again today. There will be a number of follow-ups following on from that. So moving on to Chair's business, you'll be glad to know there is none. Item 10, any other business? Just one in relation to the Committee of Agriculture, Environment and Rural Affairs is written to advise that the Minister will be holding a webinar to discuss the consultation on the draft Green Growth Strategy, Monday 29th of November at 3:45 p.m. That correspondence is found at page 47 of the table pack, and the correspondence provides a link to register for the webinar if you're interested in joining, and a link to the draft strategy. Sinead, yes?
Sorry, Chair, yes. Apologies for my late arrival. I had a bit of a technical difficulty getting in, so I was a few minutes late. But I don't know if I missed an opportunity to just put on record my condolences to the Vice Chair and constituency colleague, Sinead Ennis, on the loss of her mother.
Oh, well, thank you. I wasn't aware, Sinead.
Apologies for not bringing it earlier.
But did she pass away today?
She did yesterday.
Yesterday. Well, yeah. Can I then endorse that condolence? I had sent Sinead just correspondence a few days ago because we knew that her mother was unwell and was very unwell. But it was very sad to hear that, and we extend on behalf of the committee and the staff our condolences to Sinead. So thank you for raising that with us. Thank you, Sinead. Okay, members, if there's no other business, the date and time of the next meeting is next Tuesday, 10 a.m, room 29. Remember, we have a special meeting, Mr. Newton. Thank you. You look very surprised.
I was.
Shocked even.
Yeah, I've had the shocks of education.
Okay, thank you. Thank you very much, members. Thank you.
9:30.
9:30.
9:30 venue.
30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly